In view of the above discussions, the writ petition fails. The order passed by the Ombudsman be complied with forthwith. In the facts and circumstances of the case, there shall be no order as to costs. As also directed by my learned senior, we have added a postscript here. Observing the nature of litigation, we have to handle. So that is for this is definitely a postscript post the judgment. So that is only for the perusal of the learned counsel who are appearing.
And take into account. I agree.
Item for orders item number 2.
One.
Let's may kindly please.
One.
My lord, anything there for our guidance?
Very
That
good.
judgment. My lord, is anything there for our guidance?
That constitution bench to what extent High Court can interfere in concurrent finding of fact, whether High Court should interfere and review the technical findings of a technical body like GFR and
Right,
Ombudsman.
right.
We are, since you are asking this, we are expressing concern regarding this failure of the mechanism. Hardly there is any order of GFR and Ombudsman which has been complied to the extent, because there is no mechanism to comply, and it is being challenged here. After the
Mechanism is there only under section 142 of the act.
That's a different issue. High
Yes.
Court is not there.
High Court.
High Court is
So-
not there. Therefore, just for making the councils conscious and making the party thereby conscious, to what extent they should litigate.
Yes.
Yes.
My lord.
Item 2.
Item 2.
Let's may kindly be pleased to allow this petition IA number 4818 of 23. I've given the copy to my friend.
This is a replacement of the petitioner.
Yes.
Kerala miscase lakha, considering the rival contentions of the parties. For there is genuine request. This court allows the application, thereby permitting the petitioner to bring in change in the petitioner side. Is consolidated cost title, are you filing?
File कर दीजिए.
Okay, as undertaken, the consolidated cost title will be brought on record by Monday. Place the matter thereafter. It can
After-
be taken up only after the,
Let's say
Uh,
may after
state
vacation,
list.
let's say immediately after.
of course, this is for orders. Any interim order operating?
No, my lord. No.
Patale say listing katha lekhiwani kane, as undertaken by so and so. But have you examined whether this proceeding will be continuing any further in view of our judgment?
Only, my lord, if that
It
is,
is,
that is
you are coming after the GRF, after the ombudsman.
after. Only thing is that if it can be pointed out that some provisions has been a violation, then your lordship can intervene.
Error apparent on the face of law,
Law.
law only. Be careful. Point out that and then only.
Yes.
Hmm.
Item 3.
My lord, in this matter also subject.
3 OP number. 3, which OP will be replaced?
I think petitioner will be replaced. Yes.
Petitioner will be replaced.
Petitioner will be replaced.
Here also same order. Miscase can change over. Yes.
Can I
as
pray,
undertaken by
can I
two
pray
states.
this matter may be listed on 26th July for
No,
hearing?
this is for orders. We are
Absolutely.
not posting it. It will come after vacation.
I was only praying on after the third week of July.
We are not fixing any date now. There will be notification that you will be absent from period to so and so. So that will be taken into account. Don't worry.
I'll highly obliged.
Don't
Viewers.
worry.
Highly obliged.
Wish you a happy journey.
Obliged. So 17th.
Ah,
17th, your lordship may pick 17th.
so 17.
17 now closing week record.
I'll छुट्टी पर था उसे. छुट्टी पर आ.
छुट्टी पर था,
Ask
closing.
for now. Appeal for Chandy for OP.
Lord, senior counsel are appearing for OP1.
Yes.
Both sides senior counsels. Yes.
I was praying because I am going out. I will be
Ah,
absent.
that's
That was
right.
my.
Mr. Misra is also, Mr. Misra is appearing for OP1.
He is with us.
I am assisting.
Mr. Misra, you are appearing for?
I am
He is with
assisting
us.
Mr. Das.
Along with Mr. Das?
Yes,
Mr.
we were
Senior
together.
Councillors for OP1. Assisted by one council का name दियो तो. Assisted by.
Haripad Mahan.
Haripada Mahan.
Haripad.
Haripada
Mahanti. ହେଲା.
Great.
anchor तो Mr. Mahanti, Junior Mahanti. P Mahanti, ये PK Mahanti से P Mahanti. Yes, next.
For admission, item 4,
और एडिटर भी कॉस्ट टाइटल टा फाइल कर दीजिए कॉस्ट टाइटल फाइल लीजिए
By Monday, I think. Lordship directed by Monday.
Yes, 4, Mr. Das.
Item 4, I pray for an adjournment.
What we will be doing today? There is hardly some case.
My lord,
There is hardly some case. What we will be doing today? 2016 matter, please argue.
my
You
lord,
have come against the ombudsman. Sorry,
my lord,
CRF order.
ombudsman order only supervision charges. My lord, ombudsman is committing wrong and illegality. My lord, in one case directing that supervision charges is not payable, in other case directing supervision charges is payable. I will demonstrate that, my lord. My lord, even if we, in today's list, my lord, item 4 and 6.
No, this is already covered by our judgment.
No, my lord, illegalities, error to the law. The law is, my lord, under the remunerative scheme, my lord. Supervision charges is payable as your lordships in other case.
Is it LT connection or ST connection?
Lord, it is LT connect, HT connection, my lord.
Mr. Mahapatra, is it HT connection or LT connection?
Contract demand is, my lord.
ST connection man
LT.
ST connection man
Huh?
ST connection man
ST connection, but LT
Billing is-
metering.
My
So
lord,
this is
work,
already covered.
my lord, work was
even
done.
this 6% supervision charge
Just
also
please
be
don't-
covered by my lord's judgment.
Don't continue with,
Lord,
repeat with such.
No,
type
no,
of-
my lord, I am agree with the
And add the
lordships, my
submission
lord.
of respect.
But my lord, so far the lordship,
Sorry.
see the what is the illegality?
Sorry.
My lord, the illegality of lordship should see, my lord.
There is no illegality.
My lord, illegality, my lord,
Sorry,
may
point
see.
is already well taken
Again,
note
just
and
about-
we have already held.
Again, ଯେତେବେଳେ କହିଲେ 12 ବର୍ଷ ତଳେ
Wherever LT metering and
And the-
2016 the order, even till now.
sir 12 ବର୍ଷ ତଳେ ଯୋଉ କାମ ହେଇଥିଲା ତାକୁ କହିଲେ it is not entertainable. Ombudsman order at page 23. Only for 4-line order, my lord. I may place to bring your lordship's notice, my lord.
3.
Page 23, running page 23.
Yes.
My lord, the order award,
Hmm.
in view of the findings and a perusal of the records provided by the petitioner and the respondent, I feel that the remunerative calculation claimed for the expenditure made during the Hajare by the petitioner is not maintainable after 12 years of execution.
Yes.
The petitioner is also not entitled to get the remunerative benefit for the upgradation of work undertaken
That
by
is for
him
your benefit.
for his own assets.
Hmm.
Miller, then Miller, the second part is, I am agree with this, the 6% supervision charges claimed and received by the respondent for an amount of rupees 60,000 tanga is not admissible in view of the findings above, and the respondent should refund the same, my lord.
Right.
But, my lord, it was done 12 years back, my lord.
Hmm.
12 years back, before execution of work, my lord, he has deposited it, licensee entitled to get in view of this, my lord, regulation provided under the
Mr.
that is
Das,
already settlement.
Mr. Das, you are today ready for any interaction? You will respond or you will go on? Because that I have to clarify because we will be wasting time.
My lord, in other cases, I also you
No, this matter.
that supervision charges is.
No, this gesture and going on a speech. Will you listen to the court or not today?
Well, I am bound to listen.
No, definitely we are also bound to listen. That's
No,
not the
no,
problem.
no.
The problem is that
No.
once I open my mouth, you start go on a speech and make gestures. This 6% supervision charges you are saying, you accepted the supervision charge at the beginning,
Yes,
6% of the capital expenditure.
yes.
Now you are saying since you have accepted it, you will not refund. That is the only point after 12 years.
It's payable and we have paid.
So
he has paid.
So you, when you are saying that in view of the above discussions, it is not payable, straight away come to that discussion where it has been discussed why it is, you have to refund it. And your claim that after 12 years you cannot refund, that's not correct because you have taken the money before giving the connection
Yes.
as a condition. You are saying it is a condition.
No,
He
no
raises a
condition,
grievance.
No condition, my lord. It is requirement the
Sir,
next.
again the same problem. Today, if you decide to interact, then I will open my
Your
mouth
lordship.
or I will keep quiet also.
The provision of law in the second
Sir,
page 24, page
Sir,
24.
I'm not asking you the provision of law. I'm asking you certain facts. Did you collect or not?
My lord, if fact is, my lord.
Have you collected or not?
Yes, my lord, that is.
So you have collected, he has deposited.
Yes.
So your case is that once you are collecting, you will not refund.
No, once.
Can it be the law?
My lord, it is
So
payable.
it has to be adjudicated. It has to be adjudicated by the authority,
Yes, my lord.
who is prescribed authority. So he makes a claim, there has been adjudication.
Yes. My lord,
And here both GRF and
my
Ombudsman,
lord,
they have
my
adjudicated.
lord,
So when you are placing that part, when you are challenging that part, please develop a practice of straight away coming to that part where they have said for these reasons it is refundable.
my lord,
So that you can argue on that.
my lord, my submission is no such valid reason has been assigned as to why these supervision charges will be refunded. When the provision says that a consumer is liable to pay the 6% supervision charges when the work is undertaken by the consumer for his own benefit, my lord, for his own asset, my lord, licensee for the purpose of inspection and ensure that the work has been done under the licensee standard, my lord. My lord, that is payable, my lord. That supervision charges, the provision I have quoted under Annexure 3, my lord. Your lordship will have a glance at page 24. As per the ORC distribution conditions supply code.
Mr. Das, you can't avoid the question nor the pleading.
Sir, I was
Take page 22, take page 22 where he has discussed.
my lord.
Please take page 22 where he has
Yes,
discussed.
observation.
Observation,
Yes.
So don't be in a hurry or in jittery. Just be cool. Be cool. You are always in lot of hurry. Bring it.
The estimate sanctioned by the estimate number so and so at his own cost and in his premises, thus does not come under the capital work.
So stop there.
Yes.
So stop there and you challenge this finding.
Yes.
So straight away argue.
My lord, how the on what basis the Lord Ombudsman has said that it is not maintainable, transparent, and also is not maintainable.
Sir, should you ask this question to us
No,
or you read it?
I am asking, my lord,
Sir,
myself, my lord.
leave this
The
habit of
Ombudsman
asking questions. We are not in a school,
I
sir.
am not questioning. I am not
Sir,
questioning.
he says he gives very specific findings.
My lord.
It is again, he will not allow. Neither he will submit nor he will allow.
No.
Correct.
He has had the submission of Sri Das Lane counsel for petitioner and Sri Mahapatra for opposite parties. Read petition apparently involve a challenge to the second part of the direction by the Ombudsman in deciding consumer representation case number OM bracket -1-59 of 2016, taking this court to the plea taken by the licensee all through and the discussions as well as observation of the Ombudsman, Sri Das Lane counsel submitted. There is no discussion at all on the issue involved. And there should not have been any direction in absence of any finding to that effect.
My lord,
There
my lord,
is
one-
no-
Sense of any
my lord, may I interrupt one minute? My lord, the
Please
ground,
don't
on-
interrupt.
the
Please
ground on
don't
which,
interrupt. Please don't interrupt.
GRF
Let us complete thereafter. Yes. Perusal of the discussion and observation. This could find no doubt the licensee attempted to obstruct the claim on 6% on the supervision charges. Taking into account the submission of the licensee, the ombudsman has come to observe as follows. Page 22A. Reading the aforesaid, this court find there has been clear discussions and finding to arrive at the conclusion and the award by the serial number 2 herein. In the circumstance and for there is reasoning order by the ombudsman, this court finds no merit involving the argument made by the licensee herein. Read petition having no merit, stand dismissed. Is refund as directed by the clause 2 of award be refunded forthwith. Failure of refunding within 15 days. There shall be charging of interest at the rate 10% on the amount involved. Till realization.
my lord, at
Yes.
the same time, your lordship may see the ground on which the GRF has refused that at page 15, my lord.
Yes, all right. Dismiss accordingly.
Item 5,
Yes, 5.
Item 5, I've just paid for a password. Mr. Tripathi is on before legs before Hon'Ble Chief Justice, my lord.
All right, all right. Pass out.
item 6,
My lord, 6, my lord, my lord, brief has been transferred to Lalit Mishra today morning, my lord.
Pardon?
My brief has been transferred to Lalit Mishra.
Yes, it
So,
is
Lordship may-
submitted, it is
Lordship may call-
submitted by the Das that in the meantime, his power has been withdrawn by the licensee. There is no further appearance. Matter stand dismissed for
My lord,
nobody
today, my lord,
appearing further.
my lord, today, my lord, the brief has been,
Why are you bothering?
I have got the instruction to transfer the brief to Lalit Mishra, my lord.
Withdrawn today, hala. But however, there is no further appearance. Matter stand dismissed for non.
My lord, my lord, is a discuss.
Why are you bothering yourself?
ମତେ instruction ସକାଳ ଦେଇଛନ୍ତି
Please,
ଫେରିବାକୁ ମୁଁ
please,
ସାର୍ ତାଙ୍କୁ
please,
ପାଉନି ସାର୍
please, your chapter is closed.
Sir,
They have
sir,
taken away the brief. Why you
sir for
bother?
one day my lord it be
Sorry,
my lord I will be
you can't
They-
take your
They
power.
should not disengage you like
Why?
this. If they are doing it, the message is they should not, they cannot, or they should not disengage you. They cannot.
me that you
They have to treat the lawyer with respect.
Yes, unless they bring the.
If
fresh
they
power-
have disengaged you, they have to face the consequence. For disengaging Mr. Das. Obviously, if they have disengaged, it is their lookout. We are not,
କାଲିକି
whoever may be the.
sir it will ତାଙ୍କ ମୁଣ୍ଡରେ
Sir,
ଯିବ, sir, ମୁଁ-
sir, it may, you will never know,
Sir,
it may be mentioned today.
Item 7, my lord.
Yes,
Item 7, I have difficulty. May I pray some other day? my lord?
pardon?
Some other day may.
No, no.
I'll take instruction.
Sorry.
my lord.
Argu, we don't have case now.
I have not with the brief, that is difficult.
Yes, argu, Mr. Mahapatra.
My lord. In the, may I draw lordship's attention to the running page 14, that is the GRF order, my lord. And the order portion is 16, my lord. Page 16, my lord. It is a LI point, my lord. And we have a prayer before the GRF to consider our tariff in LI point instead of GPS, and the transformer loss they have charging transformer loss as a LT consumer ST transformer.
Yes.
And the London GRF has allowed the prayer May I read, my lord? The EC bills, electricity bills of the consumer shall be claimed on GPS LT tariff from 416. The transformer loss to be waived out from 416 onwards. The electricity bill from 416 to 1118 is to be reassessed accordingly. Meter rent collected in excess of meter cost, that is 16,600 for LTCT meter, shall be refunded by way of adjustment of the
Yes,
next.
this is dependent on the relief number 2.
My lord.
Third issue is dependent on the relief number.
Relief number 2, my lord.
So what made you
Right.
go to consumer?
I prefer before the ombudsman for restoration of power supply, because I am partly agreed, because GRF has not passed any order with regard to restoration of power supply. By the time they have,
What was your claim? Where is your claim application before GRF?
I may pardon, my lord, if you lordship.
So see how the petitions are fundamentally wrong. Withdraw. Yes.
My-
Will not ask any further any petitioner bring some documents.
my lord.
It is fundamentally incorrect.
If my lordship
Sorry,
permit me to amend
Sorry,
the petition.
even though argument has been advanced on the question of
Right.
absence of any direction by the GRF on the restoration of electricity aspect, unfortunately, the brief doesn't bear the claim before the GRF.
Let
On the ground of defective application, the petition stand dismissed.
may
Sorry, you have cause of action. You have cause of action. You may revive your prayer again.
my lord may be allowed that I may be withdraw and permitted to file a better.
So that you should have stated beginning.
My lord.
Dismissal of writ application shall not stand on the way of bringing an application for restoration of the power supply if any such cause of action still survive.
Challenging the ombudsman order.
Yes.
Instruction ନିଅନ୍ତୁ Mr. ମହାପାତ୍ର ସେ connection ନେଇସାରିଥିବେ।
The connection ନେଇଯାଇଛନ୍ତି ସେ ombudsman କଣ କରିଛନ୍ତି ନା beyond the pleading.
Sir,
Past
fundamentally
seven-
wrong ହଉଛି Mr.
ଆପଣଙ୍କ favor ରେ order ଅଛି ଆପଣ କାହିଁ challenge କରୁଥିଲେ?
Very casual.
When
filing.
my lord
Nahi,
asked you that question.
The ombudsman had a.
Anyway, you got your relief.
Item 8,
My substitution petition, lordship, flag C.
Yes, item 8.
My lord, my substitution petition, that is as flag C.
Yes, this is an application to bring in the establishment in position presently, finding genuine request. Application stand allowed. IA 3762 of 23. Yes, where is the amended cost?
My lord, I have supplied.
What is said? The amended cost title filed here be kept on record. What is this 17336?
In fact, earlier I had filed an amendment petition to amend the cost title. That was pending. Now, by filing a substitution with the
So
Bakalat number.
therefore, in view of that order,
That-
the, okay, 17336 of 21. Like for the
Yeah, that will
order
not press.
already in IA was 3762 of 23. No further is required, order is required. Okay, dispose accordingly. Yes, now argue.
My lord,
My lord, before my learned senior begins, my lord, I am appearing for the private opposite party. My lord, there is an additional affidavit filed by the petitioner as reflected in the cause list.
Why where is the scope for additional affidavit?
There is a noting, my lord, and there is an that as per the cause list, my lord. There is a
No,
noting.
we don't go by additional affidavit here.
And my lord, there is
These
an,
are all after ombudsman.
my lord,
So
Look.
therefore pleadings are already there.
My lord,
There is
my-
no question of filing any additional affidavit.
my lord, my humble submission is, my lord, I have instruction to appear. I have appeared. Your lordship takes up the matter tomorrow, my lord.
Why?
So in the morning, I received a copy of the GRF. Only
Next
tomorrow.
week.
Next week.
Place the matter next week, keeping in view the request of the counsel for opposite party.
Ma'am.
Maharana.
Ma'am.
that interim order is there. The interim order.
Interim order to continue.
Obligation.
item 9,
Item 9, my lord. I have supplied.
That my
Yes, 10,
that my Lord and friend earlier occasion
nine, yes.
Miller submitted that that bill area amount that has not been reflected for the month of energy bill of January and February 2023. I have filed this reply affidavit stating that that is a technical error because of installation of a new meter, the prepaid smart meter that
So
is
you
installed.
undertake to work out. You undertake to work out the direction ultimately.
No, no, no. Lord, I have challenged it. The GRF order of GRF that is under challenge, Your Lordship. On the twofold ground, Your Lordship, the order has passed by the Lord and GRF that is the.
No, we find surprise. What is this additional affidavit, counter affidavit, then rejoinder also?
No,
What
that is
it?
not additional affidavit. My friend earlier occasion
He
filed
filed a counter, you filed a reply affidavit.
one affidavit filed, he is not disputing, filed an affidavit stating that the bill, the area
Mr.
amount.
Tripathi, you tell the entire correct thing. The facts are like this. When you last time, before last but one the earlier occasion you argued, he said there is no area bill shown by them.
By filing an
So
affidavit.
you asked you that question, but he could not satisfy the court regarding actual payment.
Exactly.
We asked him that whether you have paid.
Well,
Then you have consulted your client. After that date, your client issued a letter stating that
that is
this
technical error.
technical error.
Mistake.
System-
So his statement is correct. Because whatever you have done is after that date when he's brought that matter to the notice of the court.
Yes.
Now you have after file said that it is a technical error. Now he files the Excel sheet.
That is a
So this court is now reduced to the level of electrical inspector.
yes.
You must because of your lackadaisical attitude. Now he says that now he is showing from September 19. Is it possible on the part of this court to go into all these details? Both of you go and you churn out these facts before the appropriate authority.
Yes, that if my friend is the OP2 is challenged.
Sir, it is not because of your friend, not because of your clients. They don't instruct you properly. And you should not have issued that letter because now that he is producing, what letter you have produced, that is after he disclosed before the
So
court.
there
Yes, that
appears
is
there
the
is a fresh
fact.
cause of
Case
action.
of action.
So therefore, go and agitate and
And
adjudicate.
Mr. Tripathi, kindly see this also.
Miller, that is the
So
doc
this,
report.
so this is a endless and aimless exercise
And
as
my-
we find.
My friend is admitting by filing this. That is a dispute over the
He's
doc
not
report.
admitting, sir. This is the
He
Excel
is
sheet you
bringing
are
the
giving.
proofs.
He is bringing this on record, trying to bring on record because of your letter.
Oh, that is also
So why
part
we
of the
stand up?
Lord, that is also part of the record of GRF. My submission twofold argument, Your Lordship. One is the prayer, beyond the prayer, the GRF has passed the order, and that is without jurisdiction.
Sir, GRF proceeding, the interpretation you are putting that everything should be stated like a plaint. CPC is applicable. Even if a person, layman, unlettered person can go to GRF and say that my electricity has been disconnected. That is enough. Don't bring strict
no,
laws of
Your
pleadings here.
Your Lordship, kindly the
Because
prayer-
then what would happen? GRF becomes otherwise it is toothless. You are not I'm having regard for the GRF, you are not obeying it. That is another part. Still, we by interpretation bring the strict laws of pleadings in GRF petition. Then how it will function? What is the you check the statute? What is the purpose of GRF?
That is the quasi judicial body.
So GRF 2004, that regulation of OERC doesn't speak about anything CPC is to be applicable. Pleadings are to be applicable.
Then the GRF can.
So you may say that while passing that order, the GRF committed error of law or error of fact. If it is a otherwise true fact, it is otherwise true, whether mentioned in the petition, in the letter or a oral complaint. How does it matter? How does it matter?
My submission for Lordship is that.
So, no.
Can
See,
the
this is a
GRF
general observation. Every day we are listening from you and we have been discussing amongst ourselves that whether we go on applying the laws of pleadings as far as complaints before GRF is concerned, a person who is stays in a slum, you expect that he will file a pleading compliant with the CPC.
Milord, it is a HT consumer. It is 70 lakhs area.
Sir, you are not listening then.
No, I am-
Did I tell you that
I
regarding this consumer? I told you that when you must understand the logic what you are arguing.
Miller,
The GRF went beyond the pleadings. And we are searching what is the pleadings. He would have written one line. My power supply has been disconnected. I am suffering. That is enough to invoke jurisdiction of GRF.
no, what is the prayer?
You see those, so any matter coming within that 10 or 20 items listed in the notification, that the GRF is well within the jurisdiction.
I am not disputing that GRF.
You may say that you did, then why after the dispute is raised, you are answering the queries of the GRF. Before the GRF, you are justifying, filing the pleadings. Then you are in a later stage, you are saying this was not scope of the jurisdiction, scope of the adjudication.
My submission for lordship, your lordship consider my submission, pass the order.
Here the address is to the Mr. Mahanti also.
Miller.
The way you are progressing every day, you are filing a new set of pleadings. Some
No, I
counter,
am not-
some calculation.
No, I have not filed. My friend filed
You are
that.
not Prasanta Kumar Tripathi, editor.
I replied.
Rejected.
You have not filed, there is no dispute.
I replied.
But have you not issued such a
Letter.
letter?
Yes,
So why did you suppress that from filing the writ application?
no, this is the cause arose in 2013 your lordship. The January, February bill that has not been reflected.
So
That was the read file in 2021 your lordship. The read petition was filed that is 2021.
21, but GRF proceeding when?
Miller.
And
GRF,
GRF dispute involves which period?
Miller,
GRF proceeding is
2019.
2019.
Miller.
So now this 2013 communication, has it been worked out or not?
Yes, question is that one smart meter that was installed in his premises, therefore the system generated a database computerized system. That error could not be reflected. That will be reflected in each month. But because of December 2022 by to smart meter was lab, set us a reflect.
Tripathi, you may purchase that story from your client.
And I am not purchasing.
Then why you are saying how the balance sheet of the person who is consuming electricity is related to meter?
Yes, this is
The balance sheet is not at all related. You are not the only person providing, or he is not the only person consuming.
Yes.
Even in case of a defective meter, still the balance sheet is maintained. The ledger is maintained.
Ledger is
So don't try to justify here, because that is beyond scope of the jurisdiction of whatever we are now adjudicating.
my submission that
We do not know who advised them to issue that letter. Now you are trying to justify that letter because some of a smart meter, earlier meter. It is a question of a continuing ledger. His account number has not been changed. His account details has not been changed. Consumer number has not been changed. You have changed the meter. You may change. You may suppose. Do you mean to say that suppose you change 12 meters in 12 months, the balance sheet will be changed?
balance cannot be changed.
So please stop there.
System,
If you say that, then we'll record and don't waste the time.
What we find, come page 34.
Miller.
He had a simple prayer before the forum that let the authority accept so and so and reconnect the power supply
Miller.
with a foundation that there has been some defect metering.
That is could not be meter, could not be there is
Okay.
not meter.
So therefore, this is a factual aspect has been gone into by the
GRF.
GRF. You said no, you have also admitted that yes, there has been some time there is defect metering.
Miller.
So how do you agree by this order?
My submission.
What is it said? It ultimately said to revise the bill of the above complaint, period from so and so, and final meter reading dividing the number of months due and duly adding area to from so and so deducting the payments. How are you agreed by
That is
this?
set aside that revision bill that we have made on the basis of DOMP report that has been set aside by the GRF when the dispute with regard to the accuracy of the meter that is to be raised before the electrical inspector. GRF has no authority, jurisdiction to entertain the matter in view of section clause 108. I have quoted in my petition, your lordship.
No metering aspect, GRF cannot go.
No, that is once accuracy is challenged, that is the electrical inspector. GRF cannot. 108, your lordship, page 4 of
Okay,
my,
come to your objection, where have you said that? Come to your objection before the GRF, where have you stated that you don't have jurisdiction?
no, that.
Sorry.
Your lordship.
Sorry, once you
paragraph
say
7.
no, you have no such pleading at all.
Paragraph 7.
You can't blame.
Paragraph 7,
Paragraph 7, read.
page 25.
Yes.
The petitioner, after receipt of the letter bearing number of such and such, 28/3/2019, gave an application for reconciliation and a revision of his energy bill. Therefore, with a view to settle the matter and know the accuracy of the existing meter, again a separate parallel meter was also.
No, where have you stated that this doesn't come within the jurisdiction of the GRF? You
That-
rather admitted that you have put up another meter and you have taken.
Accuracy taken, that a meter accuracy was taken, it was found okay. Now the question is the clause 108, you'll also kindly page 4 of my read petition. Page 4 of my read petition, that 108.
So you have not stated. Your case is that you did not state that you don't have jurisdiction, we want to go to the electrical meter.
We said,
Electrical inspector.
we said that accuracy once
No,
has been okay.
So
You
you
are
contested
answering.
that.
You contested.
You contested that.
Contested that matter. In view of
So
the,
therefore-
you have to refer
Therefore,
the
you
matter.
can't now come at the submission of the Patil and counsel for the petitioner and petitioner. Here in this read petition, the opposite party here involve the following prayer. Factual aspect appears to be consumer visited the GRF by annexure 6, clearly indicating defective metering, and as an outcome there has been defective billings. As a consequence, made a prayer before the GRF for directing the licensee to accept 1,560,000 as down payment and reconnect the power supply immediately. Power supply immediately. Proceeding was registered as GRF, case number 190/19. The main thrust of allegation of the submission of the licensee appears to be in para 7 as follows. The GRF, based on the pleadings of the parties and submissions made therein, came to observe as follows. Observation quote kariba and then order quote kariba, order time. Yes, observation, then order. Okay. Yes, in the sorry, the repetition involved challenge to this GRF order by unnecessary. The Patil and counsel appearing for the licensee, taking this court to the ground of challenge in the grounds of challenge in the writ application, highlighted the ground that for the nature of dispute involved therein, the GRF had no jurisdiction to entertain such issue. It is on the other hand, it was open to the consumer to go before the electrical engineer for
Inspector.
inspector for rectification of such a defect. In the entire reading of the objection of the petitioner, this court nowhere find. Petitioner, the licensee, this court nowhere find any such submission advanced. This court, on the other hand, finds the licensee entering into a contest, contested the submissions of the
Only after when the guest has raised this potential, this particular contents.
What's in that? Subjects are there. These are. What's it?
Sit down data, sir.
Yeah.
Mention
Yeah.
the analyst.
On the other hand, entered into contest and attempted to justify its action by replying otherwise, other than except the ground of jurisdiction.
And I have two ground rules.
33.
Okay. This court at this stage, considering the Circular number GRF 1/2004, number GRF -1/2004, dated 19th October 2004. Reading through the assignment to the GRF by clause 2.3 finds by Roman 2 and Roman 7 therein. The GRF is in very much assignment of issues relating to disconnection, reconnection supply, as well as metering. Yes, it is in this circumstance, this court find the ground of challenge that the GRF had no jurisdiction to entertain such issue falls flat, being contrary to the provision prescribed under the OERC regulation 2004, more particularly for the circular indicated herein above. Besides, the issue remaining a technical issue, GRF having power to enter into such aspects, for there is also clear finding, the observation of the GRF that through the statement prepared at page 33 of the brief, there is clear finding of the GRF that the billing up to month of April 2016 has been made correctly and as per actual consumption. And in the circumstance came to hold revision in the bill for the period involved was incorrect for a fact-finding observation of the competent authority. This court declined to entertain the questions, issues raised here. The petition suffers from merit, dismissed accordingly. The direction of the GRF, if not worked, should be worked out immediately.
Okay.
Yes.
Item 10,
Item 10 may be lordships.
Pardon?
May please your lordships. I am for the petitioner, my lords.
Pardon?
I am for the petitioner, my lords.
Yes, submit.
My lord, here, my lord, the petitioner challenges the order passed by the authority under.
Board. Just 1 minute. Board
My-
title, authority. Yes, what is this here? What is the challenge here?
Annexure 6, the order passed by the authority under the Minimum Wages Act is under challenge, my lords. My lord, the petitioner who was working under the opposite party, my lords, he filed an application under Annexure 1, the claim application regarding non-payment of some wages and weekly off days. My lords, may kindly come to Annexure 1,
Yes.
page 10.
There's-
That
There is no appeal, there is no appeal provision, or appeal is also, or this
No.
is in appeal.
My lord, this is, I mean, Minimum Wages Act, there is no appeal, my lords. In
No
payment of
appeal.
wages, no.
All right. All right, come to Annexure 1, that was the claim.
Yes, my lord. Now, my lords, I claim 95,240 differential wages and 91,000 wages for weekly days of rest. So total is 1,86,000. But as per the Minimum Wages Act, my lord, there is a clause, my lord, 10 times compensation can be claimed also. So that's why I have claimed.
Yes.
That is second. My lord. So now, my lord, your lordship may kindly see the reply submitted by the opposite party, Annexure 2, my lord.
Yes.
Page 13. They have nowhere stated anything about non-payment and all those things. What they have said, my lord, though paragraph 1, my lord, I am reading, though inviting tender quotation of Intelligence Service Bhubaneswar got the tender to supply security personnel, watch and ward, as well as sweeper to Kendriya Vidyalaya number 2 Balasore. Messrs. High Intelligence Service Bhubaneswar engaged Sri Pratap Chandra Das, the petitioner, as a security guard in KV2 agency, not the principal directly. The undersigned found several flaws that Pratap Chandra Das was not doing his duty in the allotted time in the Vidyalaya, so it was informed to the agency for necessary steps as it was related to safety and security of the Vidyalaya.
So they have taken the stand to have terminated your service.
Okay, that's a different thing. The termination is under challenge, my lords. The termination is under challenge before the CJIT, my lords. Central Government Industrial Tribunal.
My lord, I am.
That's one. So unless the termination aspect is resolved, where is the question of working out minimum wages for that period?
No, admittedly, from 17 to 19, I have worked, my lords. This is
Then
for
when?
17.
What was the date of termination?
That is after this, my lord. After the claim, that is all.
Please let us know what is the date of termination.
Annexure 6, your lordship may kindly see. That was in 20th of April 2019. 20th of April.
Okay.
20th of April 2019.
20th of April. If you find copy of that here.
No, he said, sir, that is not there, my lord. But in the impugn order, it has been mentioned in the instant case, claimant produced the proof of his salary and all those things. As regards to his termination, the matter is sub judice before CJIT.
Mr. Mishra, your claim was you are paid less.
Mine.
Your
Yes.
claim was you are paid less.
Yes.
And therefore you should be entitled to the actual wages.
Yes, bereft of my termination.
Okay. So you are engaged by whom?
They say, my case is that I was engaged by the principal directly, but the principal in Annexure 2 says that they have given it to some outsource agency and the SAI security is my employer.
Where is your engagement order?
Engagement order is not there, my lords. Now, my lords, Annexure 3, your lordship may kindly see the reply given by the SAI security, my lord, the security agency, my lords, the Annexure 3. Nowhere they have said anything on my claim. And peculiarly enough, it is not
Peculiar case, Mr. Mishra, appears to be you don't find the copy of engagement at all.
No, that is not there. But
some security officer filed some affidavit cannot establish that you are engaged by the principal employer.
No. I'm not saying, my lords, I was engaged by, my case was that I was engaged by the Kendriya Vidyalaya. Now the Kendriya Vidyalaya says I was engaged by the security agency.
That's
security
right.
agency, yes.
So therefore,
there is no dispute. Security agency, it has not said anything about my non-payment.
then you can't, Mr. Mishra, then you can't make a claim straight away from the principal employer.
No. Yes, that I understand, my lord, as your lordship rightly said, my lord.
Then you should have made a claim against the contractor. Then the principal employer has a liability.
No, that is true, my lords. But here, my lords, no evidence was that. My difficulty, my lords, here it is a case.
No, evidence. Why you expect that the principal employer will come and evidence?
No,
evidence.
I was not. Sir,
You did not make, Mr. Mishra, you did not make even your immediate employer as a party to such claim.
No,
it should have been once the principal employer say it has nowhere engaged you, the burden shift to the immediate employer. You should have made him a party.
He appeared, my lords.
No, he appeared. That's a different thing. He is not appearing as a party to contest.
Yes. OP number 4.
OP number 4 in the complaint.
No. In the complaint, my lord, the RLC implicated him as a party. Your lordship may kindly.
Where is that cost title?
Yes, kindly come to Annexure 4, Annexure 6, the impugn order. Impugn order, my lords, page 26, that Ashwini Kumar Ray, managing partner, is implicated as a party, my lords.
What was its objection?
Yes, Annexure 3, my lords.
Annexure?
Annexure 3.
3.
Yes.
Okay.
Annexure 3.
Yes, what is his stand? Please read.
My lords, the above referred matter has been brought to the notice of Messrs. High Intelligence Service on 19/11/2020 through Principal Kendriya Vidyalaya, authorizing Managing Partner Messrs. High Intelligence Service to appear on behalf of the KV number 2 Balasore. In this regard, it may be mentioned here that PC Das is staying just opposite to KV number 2 Balasore, which is running in Cyclone Sector building. When tender was brought, Messrs. High Intelligence Service come to the picture, and accordingly PC Das approached Managing Partner Messrs. High Intelligence
So
Service.
go
and-
slow here. Go
My-
slow here.
My-
Don't run away. Yes, Mr. When the tender was brought, please read it again. When the tender was brought,
Yes. Service appear on behalf of the regard may be mentioned here that PC Das is staying just opposite KB number 2 Balasore, which is running in Cyclone Shelter building.
yes, slow means don't take down your voice. I mean to say, read slowly.
Yes, yes. Now,
You are reducing your voice.
now, my lords, when
Start from when?
Tender was brought,
Hmm.
Messrs. High Intelligence Service come to the picture, and accordingly, Mr. PC Das approached Managing Partner
So
of
whose
Messrs.
employee you are? Whose employee you are?
Sai Intelligence, my lords.
By Sai agency.
That is their case, my lord. That is their case. That the Sai Intelligence is writing that after I got the contract, he approached me and I engaged him.
You
But my
engage.
case-
Then
but
your
my
complaint, your complaint prayer, have you amended?
No, but my case is that I was engaged by the principal. This paper arrangement has been made
Then
later
why
on.
don't you file? Why don't you file the appointment order?
Appointment order was not issued, my lords. Normally, they don't issue the appointment. That is,
No,
but
and your employer, your immediate employer says you are engaged by the employer, immediate employer, this high intelligence.
my lord, but here, my lord, the only thing, my lord, that payment of 95,000, your lordship may kindly say from Annexure 3-4 series, they have taken the amount. My lord, three guards were engaged by this high intelligence, and for 3 persons, they have raised the bill and taken the money, but I have been paid less. That is my case, my lord. Your lordship may kindly come to Annexure 4. How they have done all these things.
No, but you are arguing contrary. You say I am the employer of the principal employer.
That is my case. That's why I said. But ultimately, this is the thing, my lords. Your lordship may kindly come to Annexure
If this
4.
is the thing, if this is the thing,
My lord.
maybe for lawful purpose, the contractor has been added as a party. But
My
what is your prayer here? Come to see again your application prayer.
My lord.
Against whom you are making the claim?
It is prayed that a direction may be please be issued.
No, from para 6 read.
Para 6, that the opponent is legally bound to pay wages at the minimum rate of wages fixed by the government of India, but the employer has paid less wages to the applicant. The detail of which.
But
mentioned
employer,
in-
you mean always through your application is the Kendriya Vidyalaya.
My lord, my lord.
So
That is-
you
that is-
never, you never, yes, absolutely. You never claimed against the agency that has engaged you. Now come to, that must be the finding of the authority.
No, but the payment aspect, they have not said anything, my lords. Your
Pardon?
lordship regarding payment or non-payment or payment, that it is silent, order is silent. And my lords, regarding the weekly off days, it is silent. The order is totally silent, and no evidence was adduced, for which, my lords, the case it's a case of no evidence. So your lordship may remand the matter for.
No,
the-
Mr. Mishra, go slow. If your case all through was, you were engaged by the Kendriya Vidyalaya.
My lord, but later on they have made all.
Now
this
you are
paper-
banking on the pleading of the contractor that yes, you are engaged. Contractor has claimed for you
The principal,
Contractor has received the payment on behalf of you, but there is no payment. Therefore, your application was completely defective.
no, but my lords, this came when the
Therefore, you have spoiled your case, Mr. Mishra.
my lords, this Kendriya Vidyalaya filed its application in the case.
Completely, flatly denying that you were never engaged by them.
Yes, thereafter the contractor
But
came.
therefore, this is a absolutely defective application, Annex 1. This should not, and there is rejection of it. There is no, we don't find any flaw in it.
No, but your lordship may kindly see, there is nothing about, and annex 4, your lordship may kindly see, 3 guards were engaged, and for 3 guards he raised the bill and they have been paid, my lords.
But
And I
that
have
was
been,
never your case. That was never your case.
Who are they? Nobody.
Yes.
They say
That was never your case. Mr. Mishra, there is no point in submitting in this way. Your claim was something completely different.
then your lordship may.
Now that the authority has come to engage, bring the contractor, immediate employer, you started changing your tone now. You can't improve your case on the basis of the stand taken by the immediate employer. Then you should have amended your claim. It's a dead case, Mr. Mishra, for you. Yes, order is up.
Can it go back to the authority for reconsideration?
Then you withdraw this, whatever you advise, let them go.
Because it's a poor workman, that's why I'm submitting, my
No,
lord.
no, listen, poor workman or rich workman, there is no issue.
This is the reason.
Yes, absolutely. That must be, it is fundamental. Fundamental. Yes. So therefore, you find what way you will go.
I only pray your lordship to protect the poor workman, he will file, he will approach, because
No,
the
no.
order has been passed, unless your lordship may indicate something that.
See, again, you have a proceeding pending on your termination.
That is there, but
So if you
termination.
succeed there, you can revive your prayer against the employer whosoever is.
And in this case, a written statement filed by the OP2 principal and date has fixed to 16/5/2020.
That your lordship may say, my lords, and that way your lordship may dispose of saying that since the ID case is pending for termination.
In the course of submission, she Mishra and counsel for the
It came to the notice, my lords, your lordship may say.
submits that on the issue of termination. There is ID case pending, right? ID case number?
ID case number 30, my lord, 35, that is mentioned in the order.
35 of 2020.
35 of
35 of 2020.
2020. And will pursue his further remedies dependent on the outcome in the ID case number. In this observation, the petition stand closed. Yes.
My lord, disposed of.
Dispose.
My name.
For
For OP and 3, OP2 and 3.
case repeating on now 2 and 3.
2, 3, my lord.
2.
2 and 3. 2, 3, my lord.
1 man.
4 not appeared.
OP1.
4 side intention not appeared.
4 or non.
I am for 2 and 3.
Our top lekha hai tu ke ka pain achi.
My lord.
Yes.
Obliged.
Item 11. 11, your lordship may put up for some other bench, because your lordship not hearing me. And other 2, 3 matters your lordship said, so your lordship may also transfer to some other bench.
Council doesn't want the case to be heard by one of the member of the bench. Okay, this court therefore direct the registry to place the matter before Hon'Ble Chief Justice and take the matter to bench where Justice B.N.P. Ratha is not a member. Yes.
Pass over item 5.
May I please, Lordship? The order of ombudsman that is under.
पढ़ेला कि 5 टा 580 500 और थुआ है.
Challengeable Lordship, here in the question,
It I
only question
correct.
is that. Only question, cross of the issue is that whether the power factor penalty, power factor that will be calculated, including the open access consumption or excluding the open access consumption. GRF hold that we impose the penalty by including that, excluding that open access. That is correct.
Who is opposing you?
Opposite party notice in fact issued, but no one is appearing.
Notice was issued fixing 18/6/18. AD showing valid service, okay. OP2 is the contesting OP.
Millard.
All right, yes, sir, submit. It's a technical aspect, it appears.
That is technical, but two forums have passed two different orders. GRF hold that we excluding that.
As you were submitting sometime back,
Millard.
you can go to the engineer.
No, that the forum to decide.
Huh?
The power factor, the electrical inspector cannot decide.
Forum will decide, forum will
The
decide.
power factor, the electrical inspector has no jurisdiction.
So you have multiple submissions, different submissions in different cases.
No, the provision said so. The so far accuracy of the meter is concerned, the electrical inspector is the authority. The power factor is something different. There is.
Mr. Tripathi, one aspect, by this order, you want to refund something or you want to collect something? Your intention as a licensee, collect in future or already collected?
Already collected.
So you are not refunding that?
No.
You are holding on to it?
Holding that.
So we are closing this case. You raise the question in the appropriate case because the opposite party is not participating. Because you not refunding, because you definitely GRF it directs for refund, you will not refund. Ombudsman will not refund.
And if you have a remedy.
If you have a remedy, so you are happy with holding the money which has been directed to be refunded. Am I clear?
Yes,
Please correct me because don't sabu kathar ha marle kona hoba ki moro bhul type rahi.
No.
Actually correct to.
Revise kare.
Tale si to aap participate korna nahi.
Participate korna.
That is electrical inspector.
No, seri jibani se.
How?
Electric inspector power nahi.
Ka pagu jibo?
They are the ombudsman, GRF ombudsman to decide. But say leave it open. Open to any party may move to appropriate for.
Okay, all right, in the course of hearing, for technical issue involved herein, the Tripathi submits, while not pressing the writ application, the licensing should be permitted to approach competent authority available for the purpose. With this liberty, the writ petition.
Let this.
This court, it is made clear, this court has not expressed any opinion on the merit involved therein. And question of law raised herein is kept open to be adjudicated in appropriate proceeding. Mr. Mishra was, Mr. Mishra, complete that. Is
date also
filed at the SAHOO, na?
Item 17.
My lord.
34, na? 34. Yes. Listen, all hearing was almost over.
Mr. Patnaik,
Okay, some doubts
Your
were
Lordship,
there.
regarding that weapon of offense, my last occasion, my
Yes,
lord,
recovery.
that was seized by the police.
Mr. Patnaik, you are as officer of the court as he is. So what best you can defend? Upon best foot forward.
I have got.
Not like electricity matter. You take the best case. Best defense support achi. investigation, you put that.
Last occasion, Lordship was of the view that there is no discrepancy in this PW2 statement, the eyewitness to the occurrence, and the wife of the PW2 is the wife and his eyewitness to the occurrence. My lord. Lordship was
No,
of
Mr.
last-
Patnaik,
Yes, sir.
so we got your contention very clear. Yes. A conviction can result in case of a circumstantial evidence.
Yes, ma'am.
Very well. That point is very well taken, even without recovery of the weapon of offense.
Yes, ma'am.
But you have realized that day also that if you mount a case based on ocular evidence, produce a weapon of offense, whether prosecution should link that to the offense or simply saying brandishing a knife in the court will be sufficient. That you have to answer. That is how you have to make your best case.
Here in this case, with regard to.
You see, we are very clear that
Yes.
because he has to answer that regarding ocular evidence of the wife, whatever discrepancy, minor discrepancy,
Going to that.
but it is your case. You recovered the weapon of offense.
Yes.
You produced it.
Yes, sir.
FSL report also.
Yes, yes, ma'am.
There.
That
So
is
you
not-
went on that.
Yes, yes, that has not, that is the finding of the.
Or putting it differently, Mr. Patnaik,
Yes, ma'am.
you can very well say, for these reasons, we could not recover the weapon of offense. So then the court can proceed to convict also.
Yes, madam. Here in this case, madam, weapon of offense has been recovered, madam, at the instance of the investigative officer, my lord. Both we can 27
How can
because
there be recovery of weapon at the instance of investigating officer?
yes, my lord.
No, no.
He
Sorry.
on his own source, he can.
No, that's a
That's
slip
your
of tongue.
argument.
That's a slip of tongue. It can't be because then he is a party to the crime.
Sometimes, my
He's
lord.
not a
No, no.
party.
He's a part. It has to be either you then or he's having that supernatural power of knowing everything.
Your own.
Because you see, then what is the point in having section 25
Yes, madam.
or
Here-
recovery and
Admit-
whatever?
Admitting for the sake of argument, my lord. As per the finding of the learned court below, my lord. The learned court below has came to a finding, my lord. So the chemical examination report neither established that the alleged knife has been used as a weapon of offense,
That is.
nor it established that the
That
blood of the
ends the
deceased have
case.
to be. Yes, my lord.
Mr.
That-
Patnaik, we are in your favor. Let us put it that way also.
I will.
We can ignore the chemical because saying that it has deteriorated by passage of time, provided you prove that it was part of the crime. And now you are saying that IO recovered it on his own. Then he becomes a party to the whole thing. He can't be the IO also.
Both, my lord, sometimes, my
You
lord.
see, he can say that so and so person told me that the
Yes,
person
at
threw
least-
it.
At least he has heard from
Heard from
somebody
someone.
that something is lying somewhere. Maybe it might have been.
That is there.
purpose.
That is- that
Then
is-
I went. That
Not
sort of
because the
evidence
burden
is
of
not
proof-
there.
But the burden of proof here in this case lies on the IO also.
Here
And it
what
has
is-
become,
evidence.
it has become a normal scene nowadays whenever somebody is killed. ये जो कौना दे encounter कलु,
Lordship.
chase करी मारलू आमको बंदूक मारले, something is thrown there and to establish that these people are moving with arms and ammunition. So this is like that. कोठु छुरी पाइला, कोठी dead body, कि से छुरी रे रक्त और भी परीक्षा नहीं. Finding आसुची बरो,
The finding that.
finding आसुची जे it is not connected.
My lord, even the
with blood
independent
of the-
witness is the doctor, my lord.
Yes, my lord, one thing.
He
my lord,
has stated that there is
Okay,
no
okay.
blood.
corroborated by the
Alright.
doctor.
Anyway, you ponder over it. What best you can defend that
One thing,
part.
my lord,
So
I am
let
not
him
one-
complete. Let him complete.
Yes,
Let him complete.
yes, sir.
Yes, ଆପଣ grounds କିଛି ଆଉ କିଛି grounds add କରିବାକୁ ଚାହୁଁଛନ୍ତି?
My lord, only regarding PW1, my lord, the doctor, my lord. He has said that there is no, in his report doesn't disclose, my lord, I am reading. Page 25, my lord, of the paper book. The second line, my lord.
Yes.
My lord, my report does not reveal blood stain in the knife, my lord. That is there, my lord, because blood stain knife was recovered by the IO. And what is the procedure by the PM report, PM doctor, my lord, while examining weapon, my lord.
And even he has even not drawn the blood group of the accused.
My lord.
So there
In
is
forensic
question
medicine,
of
my lord,
matching even.
in forensic medicine, my lord, Dr. K.S. Narayan Reddy, he has categorically stated that any weapon, my lord, I am reading that small paragraph, my lord. Any weapon sent by the police which is alleged to have been used in producing injuries should be examined for marks of blood stain or
You are
fragments-
reading from the paper book or from
No,
something else?
I am reading from the
So you have to
book, forensic.
give a copy to all at least, because we are looking at the paper book.
In paper book, my lord, that is there. My report does not reveal blood stain in
No,
the.
that is
That's
well taken.
That
That
is
you have
there,
said that he also knows that.
Yes,
He's
sir.
saying that, no, but you are citing a authority on forensic.
Forensic. I am citing from.
So you have
a
to
book.
give that copy.
Copy
ଆମେ
ଦିଅନ୍ତୁ।
କେମିତି ପାଇବୁ? ସେଟା ଭାବନ୍ତୁ ନା।
Xerox ଦେଇଦେବି। Xerox ଦେଇଦେବି।
Copy ଦେବେ ନା।
ତାଙ୍କୁ ବି ଦେବେ, he may have a count, ମାନେ he has to answer that. He will have a
Lordship,
counter view.
In Modi also that same thing is there. I am giving them this one.
Better ଆପଣ ମୋଦି ସାଇଟ୍ କରନ୍ତୁ।
Lordship.
ମୋଦିର କୋଉ ପେଜ କୋଉ ପାରାଗ୍ରାଫ ସାଇଟ୍ କରନ୍ତୁ। କୋଉ ଭଲ୍ୟୁମ? ମୋଦିର ଲାଟେଷ୍ଟ ଭଲ୍ୟୁମ।
Latest volume ଟା ନାହିଁ ପୁରୁଣା ଟା ଥିଲା। Examination of exhibits. If a weapon alleged to have been
Devothan Patnaik hearings. Modi is now edited by Dr. Patnaik.
ମୋଦିର କଣ ସେଟା? What is that chapter?
chapter, my lord, medical
Modi-
jurisprudence chapter,
Narayan Sir.
medico-legal aspects of wounds. And my lord, I am reading examination of exhibits, which is MO1, my lord, in this case.
Retention?
Examination of exhibits.
Okay. Yes. Supply copy.
My
ଦେବେ।
lord, I'll supply the
You have to
Xerox copy.
Supply copy. Yes.
My lord, if a weapon alleged to have been used in producing the injuries is sent by the police, its shape, width, and length should be noted. It should be examined for marks of blood stain or fragments of hair, pieces of cloth, etc. That is there. That is both in Reddy and Modi. These things has been elaborately discussed, my lord. And that has not been done. The doctor has not said that, my lord. He is the independent witness. Had there been blood stain, my lord, he could have cited that. IO stated that in his evidence.
No, Mr. Mishra, you have to raise that, argument. That because here there is a strong, almost undemolished eyewitness evidence.
My lord, my
Eyewitness account remains undemolished, as we have read, as you
Yes,
have
yes,
placed
my
it.
lord. That I can develop now.
You have heard him. So
Yes,
he realizes there is a defect in subsequent. So you have to give a citation if you want acquittal. That when in such a scenario, when the eyewitness account is there, he has killed. It is corroborated also by the other two witnesses who arrived and they saw them. They saw the accused running away. Thereafter, if there is a discrepancy regarding weapon of offense, then the
And
conviction
that
is bad.
That becomes fatal.
That becomes fatal to the prosecution story. This is your
My lord,
job is cut out.
absolutely, man.
And his job is that when they present eyewitness account,
Fatal.
it may not be fatal.
Fatal. ଦିଜଣ
So say the level you have to raise to that level.
Otherwise, wife is there and it is being corroborated by two persons.
Recent judgment I have got, my lord.
Yeah.
That is the criminal appeal number 1750 or 750. That is the finding of the Honorable Supreme Court, my lord. At para 7, I'm giving the lordship.
ତାଙ୍କୁ ବି ଦେଇ ଦିଅନ୍ତୁ. Let him be satisfied.
Copy କରି ଦେଇଦେବେ ଆପଣଙ୍କ ଦିଟା।
Close କର। Yes, ଦିଟା copy ଦେଇ ଦିଅନ୍ତୁ ଆପଣ। ତାଙ୍କୁ ବି citation ଟା ତାଙ୍କୁ କହି ଦିଅନ୍ତୁ।
ହଁ, ଏଇଟା ମୁଁ ଦେଇ ଦଉଛି। Lordship, I'm just para 7, man. Para 7.
ଏଇଠି କହି
ଆଗ fact ଟା ଦେଖନ୍ତୁ।
Yes, my lord. I'm just regarding that.
judgment ହେଲେ ଆମକୁ ଚାର୍ଟ ଦେଖଉ ନା, ଶୋ ଚାର୍ଟ କର।
ଏଟା ତାଙ୍କୁ ଦିଅ।
ଶୋ ଚାର୍ଟ କର।
Regarding that.
Just 1 minute.
ଆସିଯିବ।
1 minute, 1 minute.
ଆପଣ ବି ସେ ସ୍କ୍ରିନ୍ ରେ ଦେଖିପାରିବେ।
You
Yes,
can
yes.
also give a print of that. Take down the citation, yes.
Yes, sir. Yes, ma'am.
criminal appeal.
Citation ଟା କୁହନ୍ତୁ।
citation ଟା ଖାଲି ମୋ ପାଖରେ ଏଇ ଯୋଉ
नहीं, नहीं, number
live
ଟା
law ରୁ ପାଇଛି ଏଟା ତ that is-
number टा कहना ना, case number तो अच्छी।
criminal appeal number 1750/1751 of
ठीक है,
2022
slow, ऊपर को जाए तो criminal appeal ता सेटा क्लिक करो, number कहले
criminal appeal number 1750/1751 of 2022
उधर oblique दियो तो
hyphen not hyphen that is
oblique 1751
22
ठीक है, ता 22 कर दियो।
yes my lord that is parties my lord
Supreme Court citation number known अपन जो oblique number कहउछन।
state of
MR Shah and Sudhanshu
MR Shah as Krishna Murari
ଏଇଟା ଏଇଟା ଗ୍ରୀନ ର ଷ୍ଟାଟସ ଯୋଟା
Green
ନାହିଁ,
ଉପରେ
ସେଇଟା,
ଯୋଉଟା
green ଟା।
ଅଛି।
that is
dispose ଯୋଟା ନାହିଁ
live law ର
14-10 ରେ ହେଇଛି।
my lord ହଁ 14-10 ରେ
14-10 ରେ ସେଇ judgment ଟା।
ସେଇଟା କ୍ଲିକ୍ କରିଦିଅ।
ଇଏ ନାଇଁ ଆଉ ଟିକେ ଉପରେ ଗ୍ରୀନ ଟା ହଁ ଗ୍ରୀନ ରେ ତଳକୁ
ଲାଷ୍ଟ ସେଇଟା ଯୋଟା ଲାଷ୍ଟ ମିଷ୍ଟେକ୍ ଲେଖା ହେଇଛି ଡାଇରୀ ନମ୍ବର
14-10 ଲେଖା ହେଇନି।
yes 14-10
ହଁ ସେଇଟା କ୍ଲିକ୍ କର। ଚିଫ କୋର୍ଟ ରେ କେତେ ସୁନ୍ଦର ଜଜମେଣ୍ଟ ଟା କାଢି ଦେଇ ଦଉଛନ୍ତି।
କ୍ଲିକ୍ କରୁନାହାନ୍ତି। ଆଚ୍ଛା ହାଇପରଲିଙ୍କ ହେଇନି ସେଠି ଯାଆନ୍ତୁ। कॉपी पेस्ट हबनी हेडे नेक्स्ट थांते कॉपी करी के पेस्ट कर देथांते क्रिमिनल अपील
ସେଇ ଜିନିଷ ତ ଆସୁଛି ଉପରେ ପଳେଇଲା ଗ୍ରୀନ ରେ।
और एटा केस स्टेटस न जाय कि डिसाइडेड केस रे जानतु स्टेटस तो डिस्पोजर देखेबा जजमेंट्स को जानतु। हां सेठी ए डाटाटा पुट करंतु जजमेंट डेट पकांतु क्रिमिनल अपील क्लिक करंतु नंबर पकांतु 2022 ठीक है।
ଆସିଲା ଇଏ କୋଉ ପାରା ପଡୁଛି?
para 7 my lord para 7 may I read that
हाँ yes para 7
yes sir the submission on behalf of the accused that as the original informant Mohendra has not been examined and that other independent witnesses have not been examined and the recovery open has not been proved and that there is a serious doubt about the timing and place of incident. The accused are to be acquitted cannot be accepted. Merely because the original complaint is not examined cannot be a ground to discard the deposition of PW1. As observed here above, PW1 is the eyewitness to the occurrence at both these places. Similarly, assuming that the recovery of offense, this is important, madam. Similarly, because assuming that the recovery of offense use is not established or proved, also cannot be a ground to accuse the accused, madam.
Give that copy of judgment.
Accused.
Give
When-
that copy of judgment.
When there is
So Patnaik, this is the question I was asking you. But your problem is that you have presented here there is a case, recovery of weapon is not proved.
not proved.
So there are decisions like this.
Here also
But
not
here is a case, no, recovery of weapon is proved.
here
by
not
you.
proved, madam.
It is proved.
Yes, madam, that is not proved, madam.
It is
You are
proved.
correct,
It is
sir.
proved.
The chemical
You
exam,
are saying you have presented also. The whole problem is you have created the doubt yourself.
that is the finding of the court, my lord. Under court below, lordship kind of glass, madam. The chemical exams export neither established that the alleged offense has been used in the open offense, nor it established that the blood of the weapon is found on the shirt of the accused, my lord.
ପରେ କରନ୍ତୁ please, ବ୍ୟସ୍ତ ହୁଅନ୍ତୁନି। ଆଜ୍ଞା
This is the finding of the court below, my lord.
And upon sir, this was the query from the court. In certain cases, the prosecution does not prove. Still, there can be conviction. But you have confused the case yourself.
ଦରକାର
ନଥିଲା ଆପଣଙ୍କର ଆପଣଙ୍କର ଯୋଉ ଓଭର ଜେଲସ୍ ଇନଭେଷ୍ଟିଗେସନ ହୁଏନି କି ଓଭର ଜେଲସ୍ ଇନଭେଷ୍ଟିଗେସନ ଏଇଟା ହଉଛି ପରିଣତି you demolish your case.
They are not conscious of law.
They do not understand. They do not understand जे ରାତିରେ ଯଦି ସେ ମାନେ ସେ ଦେଖି ନାହାନ୍ତି so this is a ଆପଣ ଏଇଟା ଦେଖନ୍ତୁ at least he has found this. He has to start with he has done it. So ଆପଣ ଦେଖନ୍ତୁ ଯେ it will be fatal to the prosecution case. Though not directly but that point he has said that
Yes, sir.
ଆପଣ ଯେହେତୁ ଚେଷ୍ଟା କଲେ ପ୍ରୁଭ କରିବା ପାଇଁ ଗୋଟେ କୋଉଠୁ ଆଣିଲେ ଛୁରୀ ତାକୁ ଭାବିଲେନି ଆର consequence କଣ ହବ and it's a case of proving beyond all reasonable doubt.
Yes, hearing concluded.
Yes.
Upon Sunando, Mr. Patnaik, you can file a note of grounds, note on grounds only.
Grounds,
Okay. And pointing out the evidences which you claim to be supporting.
Yes, sir.
Hearing concluded. Judgment reserved. Yes, that's all
Okay.
today.
The matter for 2 days so that we can seek instruction from the client.
It was dismissed for non-prosecution, Your Lordship. On my default, I was in court number, another court, Your Lordship.
Yes, I normally restore the matters.
My lords,
What is there to be contested?
my lords, we just
Just because you had appeared
yes, my lords.
and he had a personal difficulty as disclosed in the CMAPL. Had submission of respective counsels. Going through the grounds raised in the CMAPL, this court find prisoner has bona fide difficulty in attending the case on the date it is dismissed, involving the submission of respective counsel. This court is inclined to allow the CMAPL, thereby restoring the WPC numbers.
Lordship may direct to list the.
Yes, list the matter. It a fresh admit. This has not been admitted yet.
That has been admitted, notice was issued, they had appeared.
Okay, then it will come with.
I do not know.
Yes. Yes, item 2, Mr. Rao.
What has happened is, I have
After
taken
notice matter or fresh
matter.
fresh matter. Yes, what is your case?
My case is, my lord, I have taken 2 sheds in the IDCO and thereafter I have cleared all the dues. They have started a proceeding under estate before the estate officer. And before estate officer, I have paid by installments and cleared all the dues. Then I have applied to them to give no objection certificate and execute the lease deed. Then they have given a mail saying that please apply for revocation. I applied for revocation as per their request so that the matter can be sorted out. And immediately they have issued a letter, Annex 32, you will also see. They have said that you have to pay 15 lakhs as penalty.
Annex 36.
32.
32, page
74.
You are in possession of the property.
Yes, yes, I am in possession of the properties and I have also paid the entire dues. And it is only to be registered, lease deed is to be executed. You will also kindly see at page.
What was the agreement? Suppose if there is any condition in the agreement on revocation, there should be some charge.
No, there is nothing like that.
Where is the agreement?
Agreement is Annexure 1. Annexure 1, no such clause is there.
Allotment condition?
Allotment condition is if I fail to pay the amounts in time, 2% penal interest will be charged. At page 17. And all those things I have paid.
What was your application for revocation?
Yeah, at page
70.
70, they have requested me. It is requested to apply online for revocation of cancellation order as EO case has already been dropped before the
Issue
execution
notice
of
on
the
the
lease deed.
question of admission. Fixing short returnable date. So you have vacated the plan.
No, I am in possession and I have paid the entire dues and I have only requested them to execute the
Then
lease
what
deed.
is the outcome of revocation?
Outcome of revocation. they have
Revocation
given
of
this letter.
cancellation. Revocation of cancellation.
Yes.
Okay, all right. Yes. Requisites as undertaken by day after tomorrow, by Monday. Okay. That's all. There's no miss case.
Just now I am filing my letter.
Okay, miss case is filed in court. The registry directed to register the same. Okay, considering the matter is directed to be on issuing notice, the matter requires examination of the issue. And this would direct there shall be no coercive action against the petitioner pursuant to Annexure 32.
Item 3.
I please your lordship, my lord. I am here at VC Puri, my lord. Against the input order passed by the Chief Administrator, Lord Jagannath Temple Puri, my lord, made Annex 1, appeal is pending before the OP number 1, that is the Chief Secretary of Odisha and Special Development Commission, as well as Chairman of Appeal Subcommittee. I pray only to early disposal of the Annex 1, which is pending before the Appellate Authority, my lord.
Considering it was request involved herein. This court in the disposal of writ application observed in the event. Appeal claimed to be pending before the appellate authority by Annexure 1. Directed to be disposed of, but in accordance with law. And also in the involvement of the parties at least within a period of 4 months from the date of communication of order. Here.
Item 4.
My lord, it is not challenging the inaction regarding admission. Application
Early
number 496.
admission.
My lord.
Early admission of the
My
RP.
lord.
Fresh admission. Right.
Good night.
Item 5.
My lord, this is relating to leasehold land of Bhubaneswar, my lord, where the petitioner has purchased the same and thereafter taking permission from purchase has been issued in his favor. And
Section 22 application has been rejected.
yes, my lord, on the ground that lease has not been produced and it is covered by the recent judgment of this Hon'Ble Court, my lord, where the
No, that division bench judgment don't show here. That's a different issue. Now the rejection.
by taking into that into account, but RORs have been issued in the residents of that area, my lord.
That has been issued. There is no
My lord,
issue.
my
Then
lord.
you go to division bench and get that order. So now the question is section 22 order is challenged here.
My
The
lord,
ground of rejection is you fail to produce the certified copy. Why don't you pay?
my lord, I have applied for, but that my specific.
So therefore, I'll keep the issue open.
My
And
lord,
if
your
you
lord.
freshly approach,
I will
then this
approach them
cannot be a
freshly.
ground for rejection.
Your lordship, your lordship.
At the submission of Visual and counsel for the petitioner. Read petition involve challenge to the order at Annexure 7. appearing to be involving a proceeding under section 22 of the OSS Act 1958. Considering the reasoning grounds raised herein and coming to the finding in the rejection of such proceeding, this court find there appears there has been technical rejection of the proceeding involved. Sri Vishwa Learned Counsel here states, even though he has applied for the certified copy of the documents required for consideration for involving in the section 22 proceeding, the certified copy is yet to be copy of documents applied. Document applied is yet to be provided to the petitioner. It is in this circumstance and for there is technical dismissal of the proceeding involved herein. This court observed it may be open to the petitioner to bring the proceeding under section 22, a fresh proceeding, immediately after getting the certified copy of the WLL case number 195 of 69.
Not available. They are saying not available. Neither rejecting.
Even on the suppose it is not available, then they have to reject your application saying that it is not available.
They are not rejecting.
Then secondary evidence may be claimed.
Yes, madam.
So therefore, dependent on the outcome on the copy application pending at the instance of the petitioner. In the event a fresh proceeding is brought, the proceeding shall be decided on its own merit without being influenced by any observation in the impugned order.
Till then status quo, because I am constructing house, I am taking permission. BTA.
Who is asking you to vacate?
Yesterday some person said come and told us that you will be evicted.
That you are orally submitting. There is no such claim.
And yesterday asile mate astile ratire कहले कि
petitioner orally states there has been attempt for eviction of the petitioner. For the settled position of law, there can't be eviction without following due process of law.
Item 6.
Item 6, I need some more time because we have intimated them, but we are yet to get the instruction. This is with regard to Lord
Pension amount.
stoppage of Babu pension.
Pension amount, your lordship.
Okay, then next week, how much time?
Got
Because
time
again,
to know.
1 month, 2 months delay will be there. Why they are not giving pension? Old age pension, look to the age of the person.
88.
Look to the age of the person, 88 years. Who knows how long he will be surviving?
First week vacation first week place
Why they are not giving information?
ना सेटा कौन हेची माना मु भाबुची बोते समान हटा
This was order 1904. 3 weeks have passed in the meantime.
सेटा 9 एटा ऑर्डर पास होला 19 रे.
Place the matter on next Thursday. Instruction if any may be obtained in the meantime.
Deeply obliged.
Yes.
Item 7.
This is a case, my lords. In old Sabak settlement record of right, it was recorded as Puratan Patita. My vendor filed a revision because of the settlement authority recorded it is Godia.
This is after amendment.
After amendment. Was kind of a glass to Annex of 3, at page 45.
Page
44, 5 panels.
Yes.
So this is the order of the revisional authority. The observation is a page 46 panels, 46. Next page.
44 is not a copy of order, it's a registered sale deed.
45 panels, 45 panels.
45 settlement
Order,
15B
page
order.
46 panels.
Yes, 15B order, page 46.
Must the second person. On verification of the document filed by the petitioner and the submission made by the learned counsel for the petitioner, it is revealed that hall plot number 465 area accretion 112 decimal and plot number 911 accretion 348 decimal stands recorded in the name of Abhay Chandra Mahanti, son of Dinabandhu Mahanti, under Khata number 34 with his Sthiti 1 status. It is further contended that this original hall record tenant, namely Abhay Chandra Mahanti, died leaving behind his 3 sons, petition number 1, 2, and 3,
Right, there should not have been any direction to the Tahsildar.
Well, they are categorically observed.
He has observed.
But then what happened?
Originally it was Puratan Patita, inadvertently it has been mentioned as Gaudiya.
Gaudiya. But thereafter what the commissioner did is, they said that Tahsildar to reconsider.
Should not have been.
Should not have been. That is what my humble concern. If this portion is not sustainable, then the second thing is that what happened now.
And as a consequence, Tahsildar has passed a negative order.
Not as a consequence only. Tahsildar also didn't take note of the decision of Honorable Court, and the earlier decision, taking note of the earlier decision in Tapan Kumar Das case, said that it's not applicable.
I will just clarify, but I have gone through that judgment. Now that is the ratio decided is no disintegrate. It is settled. Now the question is, Lord, they are vendors. Admittedly, they are vendors who were in possession of the property, and during 1992 settlement operation, my Lord, the kisam was changed. And they preferred a revision, the vendors. They preferred a revision in 2007. Now, my Lord, in 2020, the revision was disposed of with a direction to the Tahsildar. Now, my Lord, the sale transaction, just before 1 month, the sale transaction took place. Since the matter was remanded to the Tahsildar, it was incumbent upon the present petitioner that they should have got themselves substituted in place of the vendor.
No, not necessarily.
They have not participated in the proceeding itself. I am showing from the order sheet.
Not necessary. That proceeding is a vexatious proceeding.
No,
once I interfere in the revisional order, then the follow-up action.
And this judgment, the judgment which has been cited by my learned friend, which my Lord's judgment, my Lord, this judgment came on 13th of April 2023.
That's why you may say that is
they have not been heard, I can show.
No, they're not necessary to go to Tahsildar, Mr. Ghosh.
I think in view of the judgment, then
15B should have settled the issue. He had no business in sending. There is wrong application by Tahsildars. That judgment is not at all applicable to these cases. Where is my order?
Copy manner that in the record manners.
Durga
that fact is also
throw blame on the parties.
So that also is not correct. No, just a minute. That is also not correct to the extent manner kind of class to Annexure 4, where I have come before the Honorable High Court. Honorable High Court directed is here as and pass order.
So that's why. That's why you participated.
Yes.
Where is my order?
I've given that copy of the order manner that is there in the record manner. I'm also giving you these 2 copies.
I will just one page 54 brief for the country.
Yes.
Page 54. Order dated 24/5/2022.
54.
Again. CR is put up after the remand. CR is put up today. Peruse the case record. Notices 54. 54. Pagination double brief.
54.
Again.
No, 54 is a pota.
Annexure 5. Again. Annexure, sir, annexure start 53 after remand.
Then it will be from Annexure 6, page 55.
Amended file is. It amended, it a consolidated. Are you holding consolidated?
Yes.
Consolidated co-annexure
page 53
page 53 is the index mutation ROR.
Page 55 page 55 hour.
55 hours. Yes, 55 is Tahsildar. Sorry, RP case order.
Again, so remand 25/4/2022 remand hela asila the case records are put, then notices were issued for first hela. In this context, this case has been instituted bearing number so and so, arising out of RP case number so and so. Notices have been issued to the parties concerned, fixing dates for hearing. But nobody is present.
Where are you reading?
I am not brief.
Page 57.
Page 56. Page 56 minutes order dated 25/4/2020.
In this context,
this case has been instituted after the remand, my Lord. Arising out of RP case number so and so, notices have been issued to the parties concerned, fixing the date 24/1/2022. 24/4 date for hearing, but nobody is present in the date fixed. Next page.
Then issue notice.
Again, notice issue. Order 24/5. CR is put up today. Peruse the case record. Notices issued as the petitioners are at present residing outside this Tahsil premises. They were contacted over phone, but nobody is present today on this court. Hence, the case is taken up today on its own merit and orders are pronounced.
Then own merit.
ସେଇଟା ମୁଁ କହୁଛି ଯେ ଏକରେ ତ ଏଇ ଜଜମେଣ୍ଟ ଟା ଆସିନଥିଲା ଆପଣଙ୍କର ଯୋଉ ଜଜମେଣ୍ଟ ଟା
So therefore, there is no question of considering that, you say.
ଏମାନେ ପାର୍ଟିସିପେଟ ତ କରିନାହାନ୍ତି ନା ସେଇ ଡେଟା ମୁଁ କହୁଛି.
They could not bring the.
Yes. ସେଇଟା ଆଣିପାରିନାହାନ୍ତି ଅର୍ଡରଟାକୁ ଆଣିନାହାନ୍ତି.
No, but what is the role of the commissioner in 15B? Whether he will decide or he will again divert the matter to the.
He has to decide. That is your lordship.
Decide. Therefore, after coming to such observation.
That hall sabikre gota entry thila.
Recorded on his own.
Yes.
The hall is in a manner. In a manner.
Hall re thila puratana patito. Sorry, sabikre thila puratana patito. Hall re jo.
Therefore, he should have simply directed for correction.
Correction.
Actually, private opposite party nahanto.
No.
Had submission of respective councils. Petition involved the following prayer. Principal ground of challenge to the impugned order appears here to be one, once there is power provided to the commissioner under the provisions of section 15B of the OSS Act. It is only the commissioner to discharge such power and he has no authority to remit the matter to the Tahsildar for involving Tahsildar's exercise in such disputes. Second limb of argument appears to be even assuming the Tahsildar has worked out on the direction of the commissioner. The Tahsildar should have confined the proceeding, considering it to be a request for correction of record of right, and in no circumstance there involved a case for conversion of land. Further argument advanced by Sri Mahapatra appears to be Tahsildar while having the remand exercise took the proceeding to be involving a request for conversion of land, and therefore there is inadvertent following of the previous judgment of this court referred to therein. It is keeping the above legal propositions, Sri Mahapatra sought for dismissal of the, setting aside of the impugned order. Sri Mahapatra also, to satisfy his such submission, brought to the notice of the order dated 29/7/22 and the judgment dated 13/4/23 passed by this court. Reading through the judgment and the order referred to herein above, Sri Mahapatra attempted to satisfy this court that it was only for the commissioner to discharge his exercise, looking to the nature of the proceeding. Okay. Sri Ghosh Learned Counsel, however, referring to several the proceeding file in the RP case number 248 of 2007.
Remand proceeding.
Miss case 29 of 21 involving RP case 248 of 2007. Reading through the different orders, page 55, 56, 56 and 57 herein, attempted to submit. In his first attempt, the first limb of submission submitted, there was no proper assistance to the court, for there has been non-appearance of the contesting parties on several occasions. Further, in reference to the judgment and order referred to herein, Sri Ghosh contends for this judgment and order came to exist subsequently There is no occasion on the part of the commissioner in
Collect Tahsildar, part of the Tahsildar.
Commissioner to refer to such orders. Further, similarly, the Tahsildar had also no occasion to go through the judgment or order passed on this particular aspect by this court in the meantime. Considering the rival contentions of the parties, attending to the validity of order in Annexure 6, this court, in reference to the pleading of the petitioner based on all record of right, appears to be a clear case of bringing in change in the status of the land mentioned in Sabikhata, and in no circumstance there involved any case for conversion. Looking to the record of rights and the discussions involving the HAL record vis-a-vis the Sabik record, this court find there should not be any doubt that there was inadvertent mentioning of the status of the land in the further preparation of the record of right. In the circumstance, looking to the nature of dispute brought under section 15B of the OSS Act, this court find, even considering the case of the petitioner, the commissioner by page 59 has come to observe as follows. Pencil mark page 59 to 60 পর্যন্ত নকলা. Okay, it is here considering the taking into account the observation of the commissioner, this court find the commissioner, even after coming to conclude that there was different recording of the status on the status of the land involved herein, and maintaining it to be Puratana Patito, there involved change in the recording of Isam of Suk property in the Samik ROR, bringing it from Puratana Patito to Gadia. The revisional authority should have stopped its exercise here and simply directing for bringing in the correction in the record of right. Further reading of the observations, this court again find tribunal, the revisional authority coming to his direction, remitting the matter to the Tahsildar for considering, keeping in view the judgment of this court in WPC 8797 of 2004 and ODC 6721 of 99, finds there has been misapplication of the judgment referred to therein to the case at hand. Deciding such issue, this court in both the order dated 29/7/22 in WPC number 14368 of 22 and the judgment dated 13/4/23 in WPC number so and so has already come to hold there is no application of the judgments by WPC 8797 of 2004 as well as OJC 6721 of 99. In this circumstance, this court set aside the direction part appearing at page 60 and 61 of the brief.
Annexure 6.
Involving Annexure 6, page at the end of page 60, continuing till page 61. At end para, and remit the matter back to the revisional authority
That's Tahsildar, no?
for giving the rightful declaration, bringing in the status of the disputed land involved herein from inverted comma Godia to Godia oblique Jalasha to Puratan Patito by completing his exercise at least within a period of 1 month from the date of communication of order. As a consequence of interference in the order at Annexure 6, this court find the further order by the Tahsildar
সেটা Annexure 6 টা হচ্ছে তহসিলদার order.
Sorry, huh?
Annexure 3 টা হচ্ছে
Oh, it is, sorry. Annexure 3.
Annexure 3 হচ্ছে order of the
Oh,
commissioner.
sorry, ଶୁଣ ଯୋଉ quotation କରିବନି quotation ଟା ହଉଛି page 46 ରୁ page 46 ରୁ 47 ପର୍ଯ୍ୟନ୍ତ. This is Annexure
3.
3.
Annexure 3 page 46.
46.
46, 47.
Okay, it is 46 ର ଏ portion ଟା କରିବ ହେଲା. As a consequence, this court interferes in the remand order Annexure 6 and set aside the same. Hello. If the petition succeed, however, there is no order as to pass. Draft for the one.
Sir, there may be direction to Tahsildar to effect the correction. Direction to Tahsildar to effect the correction.
No, I have remitted the matter back to the revisional authority for passing an order in the conversion of the land. So follow-up action will be by the Tahsildar.
Okay. So only thing is that, my lords, because the persons who have sold my vendors, they are not coming to the picture. I may be allowed to.
They may not be. They may not be. But once the yes, for the this court records the submission of Sri Mahapatra that there has been subsequent sales and none of the vendors are cooperating presently. In such event, it may be open to the petitioner herein to pursue the litigation in RP case number
248 of 2007.
248 of
2007.
2007. That's meant over. Yes, rest of the cases after recess.
May I please, Your Lordship?
My
Lordship,
lord,
kindly. Just a minute.
Item 8, 9, 10. I am appearing through caveat for the opposite party. I got the copy of the writ petition yesterday night. I am not ready, my lord. So I pray.
No,
let
your
it
role
come
may
next
be
week.
for interim order.
My lord.
Your role may be for interim order.
Yes, ma'am.
So let us hear the matter for admission.
Yes.
Lordship.
Yes.
Here the order of the MSME is under challenge. Lordship, may kindly have a glance at page 75. I had raised an objection to the maintainability of the proceeding.
Page 75.
Page 75.
Yes.
The second last paragraph.
Yes.
Before dealing with the bill-wise claims of KCS Private Limited on merit, preliminary objection is taken regarding the maintainability of claim on the following ground. KCS Limited got registered under MSME by registration certificate dated 16/12/2016. However, KCS had abandoned the project much earlier in January 2013 by the letter dated 28/1/13, In the next page, I have also referred to Supreme Court judgments, and also there is another recent Supreme Court judgment which says that the agreement has to be after the registration. Here, the agreement was of 2010. He has been registered under MSME in 2016. And this maintainability issue has not been decided also. Your Lordship's recent judgment also, I was arguing that case. I have given the list of judgments. That has also not been challenged in writ appeal or Supreme Court. Lordship has held that maintainability is to be decided first, but he has not.
Definitely, before proceeding there should be a decision on the
Maintainability. Issue has not at all been decided.
Then has he gone to the merit of the case?
Yes, he has gone to the merit. Page 88, MSME has agreed with me that the registration is of 2016. Lordship may see page 88. That is part of the impugned order. Page 88, third paragraph. The petitioner is a MSME unit having UAS RC number dated 16/12/2016 and engaged in manufacture of these products. Then the next page, next paragraph, opposite party is a public sector undertaking, that is the present petitioner. In the next paragraph, the work order date has.
Therefore, short question is, Mr. Roy.
Yes, ma'am.
Short question here, has he gone into maintainability aspect?
No.
2007, my lord, I have been registered.
Pardon?
2007, from 2007.
Yes.
I have filed the documents.
That's right. If a question of maintainability is raised, whether it will be decided or not, because he is discussing.
No.
He is discussing, taking note of the same.
My lord,
Therefore, if you agree, I can set aside the order and send back to this stage of maintainability.
Lordship.
If you don't agree, then I have to examine this aspect, I'll grant stay.
no, this writ petition is not maintainable because it's a award construed as a award under arbitration
No, on the
and
question of
conciliation act.
maintainability, if not decided, then why should one go in appeal? Had issue notice on the question of admission.
Your lordship, kindly, before section 19, they
I'll examine, give you
mandatory
opportunity
to
of hearing.
deposit 75%.
I'll give you opportunity of hearing, there's no issue. I am admitting the matter. Once I admit, there should be stay of operation of order. And you raise your objection, whatever there. Since there is already appearance on behalf of the opposite party, private opposite party. You have already served copy?
Yes.
Okay, there is already service of copy of the petition, a brief on Sri Subhendu Kumar Rai appearing for such party. No notice further be issued. Objection, if any, be brought within 3 weeks. Okay. This case notice as above. There shall be August 2nd week. Matter to come in August 2nd week, date though. Okay, in the meantime, there shall be stay of the operation of order till next day. Minus of 5. Yes.
Obligation.
Your lordship may fix a date so that.
Yes, August 2nd week date is fixed.
My lord.
9-10 also same.
Same night.
Item 11.
Yes, 11, Mr. Misra.
May I please, your lordship? Well, here I am a ST person. I sought for permission to transfer my land. Now
Section 22.
it is in the schedule,
Or
schedule
OSA.
area. Regulation.
Regulation 2.
Yes. And the sub-collector says, since in the amended regulation, there is no provision for transfer. So he has rejected. Page 10, my lord.
Yes, page 10 I'm holding.
On perusal of the petition under section 3 of the so and so, the petition.
The amended regulation is not wholly taking away the original statute. It's only amendment of certain portions, section 3. There is the
The-
amendment.
There is a provision in the rule exists, rule is not amended. The
All right,
pro-
you saw copy, let them examine. You should notice on the question of admission. Notice by way of service of copy. Only your state is the only party.
Yes, my lord.
They place this matter immediately after vacation.
Well, let's say me give me a date because I want to transfer to liquidate some loan. The loan notice I have annexed.
Okay, okay. Second week of July.
Item 12.
May it please, my lord. I am a bona fide lessee and I have, with requisite permissions from the government, my lords, I have been conducting my mining operations. There was a, my lords, complaint filed before the Lokayu that there is some illegal mining going on and all that with a lot of allegations. Then, my lords, Annexure 12. All honest, without notice to me, the Lokayuk directs for an inquiry by the vigilance. And Annexure 13 at page 113, I suddenly get a notice from the SP, DSP vigilance to appear
No,
for.
but Lokayut said none of the parties appears.
No, I was not even noticed. I have not been noticed.
Are you a party to the Lokayut proceeding?
No, I am not a party, but yet I am part of the inquiry. Inquiry has been ordered.
Where is the cost title of the Lokayut proceeding?
My lord's cross title is here. No, since I am not, my lord, they are not even cooperating, giving me the order.
Pardon?
They are not giving me the copies of the orders.
How could
I
you get-
got it from Annexure 13, your lordship may get it. Vigilance cell number so and so, arising out of Lokayuk case number LY 870 of 2021. To Shri so and so.
Then
To attend inquiry.
even looking to the order 2322,
My lord.
1 year have passed.
My lord, I get the notice on.
And what is the level of inquiry? Mr. Pali sees 112.
My lord, preliminary.
It's only
inquiry.
for a preliminary inquiry.
Even for that, my lords, the statute is very clear.
So the Lokayut Act.
My lord, even for that. Section 21.
He is simply calling for a preliminary inquiry through its vigilance.
My lord, the act says subject to.
Just
my lord,
1 minute. Act says before passing order against you.
If at any stage in the proceeding,
Yes.
the Lokayukta considers it necessary to inquire into the conduct of any person other than the accused. Normally, the accused will be a government officer. I am a private person. Is of the opinion that the reputation of any person other than the accused is likely to be prejudicially affected by the preliminary inquiry. He is talking about preliminary inquiry here. It shall give to that person a reasonable opportunity of being heard in the preliminary inquiry.
So therefore, it is after the preliminary inquiry only.
In the inquiry, prior to.
No. Read B again.
My lord, is of the opinion that the reputation of any person other than the accused is likely to be prejudicially affected by the preliminary inquiry.
Yes, if preliminary inquiry indices you,
My lord,
then only you will be likely to be affected. So therefore, on the report being submitted before passing further order, he must give you an opportunity.
My lord,
Not prior to that. And now come to next page, 113.
My lord.
He is giving you opportunity to come and attend.
My lord, my submission to that is, my lord, is this, that even before.
On the allegation of illegal mining Clockstone, so and so, the above noted Lokayuta has been initiated, the proceeding has been initiated, and
prior to that,
inquired into, you have been allotted with so and so. So your examination is required in connection. Therefore, it's only in the preparation of the report.
My lord, prior to that, he makes up his mind here. Page 112. If your lordship takes cognizance of this.
Yes.
None appears for the parties, meaning the complainant also never appeared. He just filed again. The present complaint is alleged That rampant illegal mining of blackstone is being carried out in Bajavati Hills, Tahsil Dharmasala, District Jajpur in collusion with district authority. In response to the notice, Collector Jajpur and Tahsildar Dharmasala have
Come to fourth para.
Manner.
Be that as
Be
it
that,
may.
yes, manner. Be that as it may, the allegation of illegal mining made in the complaint itself could not be denied by the Collector Jajpur. Manner, I was not given an opportunity here.
No, not necessary at this stage, Mr. Pali. What he is directing, we therefore in exercise of power, deem it proper to direct the Director of Vigilance to conduct a preliminary inquiry.
Correct,
For ascertaining whether there exists a prima facie case. So prima facie case is yet to be found. It's only when the prima facie case is found, you may be provided with a report, you may be provided with an opportunity of objection. This is no stage. Wait till inquiry report is there. Now you can't apprehend. It may come in your favor.
My submission is this manner, that even at this stage, there is some sort of a pre-prima facie satisfaction.
No. They have a duty. They have a duty. For the purpose they have been created, they have a duty to inquire first, obtain the preliminary inquiry report, then they used to proceed. So then this provision comes in.
Preliminary inquiry, rightly as your lordship is pointing out, preliminary inquiry would end up in a report which would,
if it indicts you.
which would indict leading to a culpability.
Absolutely. Then
Now,
a prima facie case comes to exist. Then before proceeding further, you will be provided opportunity, not at this stage.
I bow down that manner. My submission here is this manner. That
and looking to page 113 development, you are already involved in that. You have been asked to for statement, recording of statement only.
Yes.
So therefore, let that stage come.
My only submission here, subject to what your lordship appreciates, and how your lordship appreciates, my only submission is, if the collector was given and Tahsildar was given an opportunity to file a counter, was I not entitled to?
Mr. Pali, se Odia re saying achi, dase jaitile phandi ku. Apon birudhare prima facie case asini, apon kahi opportunity diya habo? Apon birudhare it is yet to be ascertained. The prima facie case is yet to be ascertained. Why should you go there? Why should you be dragged to court, dragged to litigation? You are troubling your client, Mr. Pali.
No. This your lordship, that section considers it necessary to inquire if at any stage of the proceeding, the Lokayuk considers it necessary to inquire into the conduct of any person other than the accused, or it's an or, manner. I'll pause here, or is of the opinion that the reputation of such and such person other than the
let
accused,
that stage come.
it shall give.
Let that stage come.
But I would interpret it.
No, it will be as if upon filing a FIR, the accused will be called to Thana to have his explanation. Inquiry may be there. If the inquiry ultimately brings you to the court of investigation, then you are definitely given an opportunity.
I was only that, am I not entitled to tell the my lords?
No, it is not at this stage. Not at this
My lord,
stage.
in the event, what is my protection otherwise? In the event, the collector holds some grudge against me, or the Tahsildar holds some grudge against me, for whatever reason.
Now they are nothing to hold. It's a complaint.
My lord, even at that stage, my submission, grateful my lord, only my submission, that supposing, what is my protection against an
Your protection is safeguarded by the notice page 150.
against an arbitrary, my lords, against an arbitrary counter.
Sorry, page 13, page 113, Annex 13, you are provided with opportunity. Go and explain that you are not
I have already gone and explained.
Therefore, let us wait for the report.
I have already gone and explained.
Let us wait.
But my entire contention was, if the collector's one-sided ballots, unilateral affidavit countered by the collector and the Tahsildar forms the basis of this order.
Take the order. I am not satisfied, Mr. Pandit.
My lord,
I am not satisfied. It is up to you. If you don't withdraw, then I am to pass order. It's not a case entertainable at this stage.
My lords, it's a question of my right to be heard. I was only on that.
No, you will be provided. Why are you presuming now? And as a matter of fact, opportunity has started flowing to you. Vigilance has already called you to give your statement. Then it is likely to file a report against you, or even may not be filing a report against you.
Malad,
Why are you presupposing something now?
My submission would draw also some sustenance from your lordship's judgment sitting with the erstwhile Chief Justice, my lords, where your lordships had quashed the order of the Lokayuk. Then it went to the Supreme Court.
No, that went
My lord, Supreme Court
in a
said,
bizarre way in Supreme Court. The matter, you know what was that case? That was a case Lokayuta contested here the judgment of the division bench.
My lord,
Then
that
we
is
said,
not-
who is Lokayuta? Lokayuta is a body, adjudicatory body. Why
My
should it challenge our order?
my lord,
If party agree, then we can entertain.
my lord,
So that's how we rejected.
my lord.
Now matter went to Supreme Court to examine
My lord.
whether Lokayuta can bring a review or not.
My lord. It
Now
passed
in the
different
Supreme
order.
Court, inquiry completed, man is likely to be punished. That is what Supreme Court done. So let us not
My lord,
discuss
I am
much on
only
that.
relying on the reverse
So
proposition.
therefore,
If the Supreme Court
it's
should
your
interfere,
choice, it's your choice. Opportunity will be definitely provided after the preliminary report comes against you.
if your lordship observes, then I'll be in
So
difficulty.
therefore, better withdraw, pursue remedy at appropriate stage.
Or your lordship may give me a liberty to come again if I'm
Yes,
prejudiced.
yes, yes.
That liberty may
Mr.
be
Palit wants
kindly
to withdraw
provided.
the litigation, not pursuing the prayer involved herein for the timing, and keeps liberty to approach this court in the event any such situation arises.
Great, great.
Yes, with this liberty.
With the liberty, madam. Great.
तार judgment देखो लोकायुक्तर से judgment Supreme Court रे कौन है?
अच्छी सी judgment तो अच्छी
And
सी-
there is no answer. There is
Supreme
no
Court-
answer
no
whether
answer, Supreme Court
whether
said-
Lokayukta is entitled to bring a
I was only
review.
trying to point out that Supreme Court said the Lokayuk should be heard. No order could have been passed without hearing the Lokayuk.
Where it is?
In this 2023 Supreme Court, Supreme Court page 1202.
No, at the same time, Supreme Court has said Lokayukta, Women Commission need not be bringing litigations. They are
That is
adjudicatory
also
authority.
there is another line.
See how Lokayukta or National Human Rights Commission or Women Commission to come to court to justify their orders. Is it ever possible?
No. Not heard of. Well, I was only saying that if the Lokayuk could get a mandate for hearing, why,
No, but the
why
purpose
not an ordinary citizen?
purpose of Lokayut, there is creation of a statute, so they must get into an inquiry. They're teethless tigers. Teethless tigers. They can simply give some direction. All right, commence an inquiry.
No, now they have
Give
given
so
them
much
teeth.
amount to so and so.
One of those teeth is also there, Caesar and all that
Yes,
is
it
there.
is because
They
of
provided
us.
this teeth.
Because of us.
I was only that if an ordinary citizen can be dragged into an inquiry, before that he should be heard.
Mr. Pali, there is
That is the
some
basic.
reasoning in bringing the statute. Therefore, let us not
No, I'm not.
converse much.
I'm not. My lords,
All right,
resisting the
yes,
statute.
Next.
Great for that.
Item 13.
May I please, your lords. Lord, I am on behalf of Mr. Satpathy.
Pardon? Yes, on behalf
Last
of
time.
Mr. Satpathy. You
Yes,
have
my
your
last-
power.
Yes, my
Power
lord.
nahi, achi.
Yes, my
You
lord,
are
I
SK
have.
Mishra.
Yes, my lord.
Okay, all right, argue.
Yes, my lord. My lord, in this matter, the petitioner applied for demarcation of his land.
Proceeding is still pending.
Yes, my lord. Subsequently, he paid the fees and Tahsildar directed the revenue inspector for demarcation. Your lordship may kindly turn to page 14. The
Page
direction of
14?
the yes, my lord.
Yes.
Tahsildar to the revenue inspector. But on the date of demarcation,
Last time, my lord,
You
I
are
have
taking
produced
time.
that I have produced that record. Your lordship call for that record.
Yes. What was the direction last time?
Your lordship
Find
kindly
change in the
21
tendency of such proceeding, direct the learned counsel to serve to extra copies. So now what is the position?
Position RI report then. Your lordship may kindly see Roman 6.
RI has not given report. Why it is taking so much time?
Your lordship may directly. Roman 6, your lordship.
Proceeding initiated when? Demarcation proceeding initiated when? 21. Okay, I had the submission of learned counsel. Revision involved the following prayer. Finding pendency of demarcation case 79 of 2021 for nearly 2 years. This court by order dated 21/4/23 passed the following. Today in course of hearing, bringing out the order sheet of the Tahsildar, it is claimed the proceeding is pending for awaiting the report of the RI. Considering the observations in the demarcation file, proceeding file, this court observed disposal of demarcation proceeding should not take so much time. In the event the RI is not providing necessary report, there is nothing prevented the Tahsildar to take steps as appropriate for early receipt of the report. But no party should suffer on account of laches in the administrative side. Be that as it may, for pendency of the demarcation proceeding, this court, in the disposal of the proceeding, direct the Tahsildar, Nabrangpur.
Yes, ma'am.
Tahsildar
Umarkot. Tahsildar Umarkot.
Okay. To conclude the proceeding in accordance with law, ensuring receipt of RI report at least within a period of 15 days hence, and by showing lawful disposal to the proceeding within 2 months in the involvement of the boundary tenants, if any. Records be returned to Government Council.
Copy of the order, Your
Free
Lord.
copy of order be handed over to State Council.
Item 14, my lord. Despite of order of this honorable court in
Just
WPC.
be on mic.
Despite of order of this honorable court at page 19 in
Yes.
WPC and also order passed in content, my lord, certified copy of orders of mutation case is not yet been granted. Annexure 8 series, the copy of application filed on 28/9/2022.
Contempt also there.
Again.
Even thereafter, there is no disposal.
ना से कंटेम्प्ट रे कहि देले जे हमें ऑर्डर कर देइछु किंतु ऑर्डर कॉपी दउ नांती सेप्टेम्बर 22 रु
Seta,
then what
I have already taken instruction, my lord. He will supply certified copy by tomorrow.
Okay, the read petition involved a serious
Or
grievance.
Monday, Your Lordship.
Even after disposal of mutation case 4/19, following direction in the read application as well as observation in contempt application, so and so kariba. There is no supplying of copy of order involving mutation case 4/19. Sri Ponda appearing for Learned AG appearing for Tahsildar Daringbadi submits. There is already steps in handing over the certified copy of the order to the petitioner herein. Okay, let the copy of the final order be supplied to the petitioner within 3 working days of this order. Copy of order be handed over to Sri Ponda. Yes.
Copy application annexure 8 series. Copy application is annexed to annexure 8
Yes,
series.
following copy application annexure 8.
8 series.
Right. All right. Right, you have heard him. Your client might have got the copy by now.
Na pai na.
May I please,
Yes.
Your Lordship? My lord, the petitioner is challenging the inaction on the part of the Revenue Authority, my lord,
Yes.
in confirming the declaration in favor of Bhudana Samiti, my lord. Similar matters are also pending before this
Oh, the
order.
Bhudan case.
My lord, similar matters are pending.
Indian order. Yes, similar order.
Item 16.
Yes, 16.
Madam, IA is there, my lord. I have filed an IA, my lord, for interim protection.
The order of the previous case
Yes,
will
ma'am.
be followed. I re stay achi kis tarah ki.
Right.
All right. IA, you are filing here.
Yes, my lord.
You have filed IA already there. So आइरे order हबा होगी अच्छे ना देखो last to देखो yes it interim order will be there, notice has been issued and there is direction for maintenance. Yes.
Obliged, ma'am.
Yes, Mr. Rai.
My learned senior was supposed to take instruction as to whether the case of the petitioner is covered by the case of Dr. Sahaswati Mahapatra, my lord.
Yes, Mr. Mahapatra.
Item 16.
So with due humility, my lords, I have not noted that listing of the case today, my lords.
Pardon?
I have not noted that case today, my lords.
Then let it come next Wednesday. Place the matter on Wednesday, keeping in view the request of Mr. Mahapatra, who appears for the Development Authority, registry directed to indicate name of Mr. Mahapatra in the next listing on Wednesday.
Grateful.
Item 17.
May I please note?
Yes.
In this case, my lord, the petitioner appointed a recognized agent to appear before the revisional court. But the court dismissed the same, saying no one present before this court.
Why? There is some proceeding pending.
Yes, ma'am.
There is some proceeding pending under section 15 of the Act.
Yes, ma'am.
So why you want to be represented by a representative again? So this has been dismissed for default.
Yes, ma'am.
The
Only
State
prayer is
Council,
to
let him
allow
restore
the
the matter, let him get the
restore and
contest.
allow the agent.
State Council, come to page 14. 15B proceeding has been dismissed for non-prosecution. So let us set aside the order at the submission of the respective councils.
Standing council भी पार्टी कर दीजिए.
No, standing council, government advocate is present. Data
नहीं से first title से standing council भी पार्टी कर दीजिए.
हाँ right. এটা কাহা কোর্ট?
এটা হচ্ছে additional commissioner court number 4 Bhubaneswar.
Who is the standing council? You know who is the standing council?
No, madam.
And then it may be difficulty. There may be difficulties. You first find out who was the standing council appeared there on that date. I am bringing this at on Monday.
नहीं এটা করছেন এটা.
Only prayer is to allow the.
No, question is if X has appeared.
नहीं ସେଥିରେ ଏ କେସରେ ହେଇନଥିବ.
ସେଠି ମହେଶ ସେଠି କିଏ ଅଛନ୍ତି ନାଇଁ?
ହଁ.
PK Tripathi, NP Singh, ଏଟା କେତେ number serial ଥିଲା ଏଠି page 13, page 12? Page 21 of 22 na?
14, 15, 16.
14, 15, 16.
Case number 21 of 22.
Thank you.
Okay, additional standing council.
16 and 17.
All right. Petition involve the following prayer. After involving the rival contentions, this court find the proceeding 21/22 has been dismissed for non-prosecution of the petitioner. Through the writ application, the counsel for the petitioner clearly indicates the reason of non-appearance. Considering genuine reason, this court is inclined to allow the writ application, thereby interfering in the order dated 14/12/22 in proceeding 21 of 2022, set aside the same and stop version for the revision required to be freshly adjudicated in the involvement of the petitioner. Proceeding is remanded back to the additional commissioner, additional revisional court number 4, Roman 4, for fresh adjudication in the involvement of the petitioner. Petitioner hearing is also directed to appear before the competent court along with copy of order of this court on 18th of May.
Item 18 also same.
18 same.
18 also same.
18th of May, date of appearance.
Serial
18
number,
also same.
item number 18 also
18.
Same. Same.
Again.
Well,
All right, same. Case number 20/22.
Item 19.
Demarcation proceeding ଗତକାଲି ଗୋଟେ ଏଇ ଲୋକର disposal ହେଇଥିଲା I want because ତହସିଲଦାର same but ଖାତାs different ସେଇ ପାଇଁ ଦିଟା ରିଟ୍ ହେଇଥିଲା 13,509/23 ସେଇ ଅର୍ଡରଟା I pray ଗତକାଲିର ଅର୍ଡରଟା OP same ତହସିଲଦାର ବାରଙ୍ଗ
Which item?
WPC 1350
Which item yesterday? Which item?
My lord yesterday
Item कौन?
17 ନା ଦେଖ ଡବଲ ପିସ୍ଟା ମୁଁ ଆଇଟମ ଦେଖି କହିଦେବି
Item slip लिखी दो.
ଆଜ୍ଞା ଆଜ୍ଞା
Next.
Item 20.
Item and read application number both indicate in slip.
Item 20, revision petition pending for a fresh admission.
It has not been admitted as of
No.
now. Okay, fresh admission.
Item 21.
I have completed works given to me by the opposite party corporation. My claim regarding my outstanding dues is pending before Executive Director of number 2, Annexure 3 and 4 series.
We are instructed to appear on behalf of the opposite party OPG Power Grid Corporation. But let a copy be handed over to me.
Directed,
I record your name and dispose.
I have
What
submitted.
is there to be decided here? His application is pending and the authority is to take a decision.
Executive Director of number 2.
Okay, had the submission of SAHOO and also the submission of SEKHAR. N sir.
N Das and N Sir.
N Das and N SEKHAR, who have the instruction to appear for Power Grid Corporation Limited. Opposite party number 1. Okay, considering the submission, perusal of the proceeding documents in the writ application, this court find on the self-same issue, petitioner has pending request before the
Executive Director of
General Manager, Power Grid Corporation of India, OP number?
OP number 2.
2.
Madam.
OP 2. For the disclosures on the top of the page 13, there appears there has been some progress on such application. Keeping in view matter is still pending in the hand of the opposite party number 2, finding repetition premature at this stage. This court disposes the writ application directing OP number 2 to take a lawful decision on the request of the petitioner by completing such exercise at least within a period of 2 months from the date of communication of order.
Or production of my lord's order. Or production of my lord's certified copy of certified copy.
Yes.
Oblige.
Item 22.
Yes. ତାଙ୍କୁ ଦିଅନ୍ତୁ କପି ଦଉନାହାନ୍ତି। This was listed earlier.
My lord.
This was listed earlier.
Yesterday, day before yesterday.
Army Jawan case.
Jawan lease, my lord.
Jawan lease.
My lord.
Oh, you say war. All right, what to do? Pass for your same order. This fellow had also earlier come to High Court.
This person earlier had approached this Hon'Ble Court in the year 2020 and subsequently in the year 2022.
Where are those orders?
The lordships can find at Annexure 9, page 37.
Page 37.
Yes, my lord.
No, Justice Mahapatran's order, Nakar Rita.
Agya.
Now there is final order.
Yes, my lord. And again, when that order was, by that order, the ASO initiated the objection case and thereafter transferred the case to the Tahsildar. Again, that order was challenged before this honorable court in the year 2022 in a double piece number 4.
This court again remanded the matter.
Yes, my lord. 49Y for page 49.
Right. All right, you go through this. I will be passing a judgment here itself. Same case, definitely, but again, order of this court involved. This your claim is rejected on account of non-production of the
Documents,
WLL
my lord.
file.
Yes, my lord.
WLL file.
My lord.
Tomorrow. In the meantime, you go through the order. Tomorrow I'll dictate the order here.
Yes, my lord.
Okay, all right. You just give in a slip, or else you can indicate, take back the judgment.
Your lordship, keep it, I have a judgment.
Make necessary corrections here. Looking to your previous case number. All right.
My lord.
Yes. Just have pencil numbering, sir.
Yes, my lord.
Corrections in pencil. Yes.
23 is my lord same.
Both the
24
cases.
same, 25 same, but 26 is different.
20, this is 22,
23,
23 and
20.
24.
25.
25 also same.
My lord.
All right. So tomorrow you give in memo the case numbers already involved of this court as well as the WLL number.
My lord.
So that dictation will be easy.
My lord. What item 26, my lord?
Hmm.
That is different. General lease was granted to the lessee.
Just 1 minute, 1 minute. Let me clear the file. Yes, 26, what is there? Yes, 26, what is the difference you claim?
This is my lord general lease.
General?
Lease, my lord.
Okay, general lease.
My lord.
Then take notice here. Notice. Status quo. Miscase achi?
No, my lord. Miscase.
Miscase nahi?
No.
All right. Only notice. Yes.
Item
One more
27.
solution, my lord. In that, yes, my lord, notice.
Yes, 27.
May I please, your lords? In my prior portion, my lord, in page 29, there is a small mistake, that is the annexure 8. It has mistakes written annexure 7, my lord.
You want to correct it?
It has to only correct it, only that is a typographical error, my lord.
My lord.
It is mentioned as annexure 7, but it's annexure 8 because you are
So
challenging
oral, on oral prayer,
No.
counsel for the.
My lord cannot hear.
I can't hear.
Page 58.
All right, for the counsel appearing. Government counsel appearing in the EHS, definitely. 69 also.
Yes,
He
yes,
was
yes,
at.
yes.
This court unable to hear the matter. Place this matter before other bench after taking consent of the Honorable Chief Justice. ଆପଣ ନିଜ ଆଡୁ କହିବା କଥା ସେଟା ଜାଣିନାହାନ୍ତି ଷ୍ଟାଣ୍ଡିଂ କାଉନସିଲ କିଏ?
Item 28.
Covered other lordship's judgment, my lord. That is covered your lordship's judgment.
Cover ହେଲେ ତାଙ୍କୁ କପି ଫପି ଦଉନି
Cover କିନ୍ତୁ ସେ prayer ଟା correction କରିବେ.
prayer correction କରିବା ପାଇଁ ଯୋଉ ହଉନି order. On oral submission, counsel for petitioner is permitted to make necessary correction in the prayer portion. So you will involve the challenge to the annexure. Baki covered order. Yeah.
Item 29.
Item 29, my lords. My lords, may I please? The lordships, after hearing this matter, was pleased to direct for instructions from the state government as to why that inquiry meeting.
23 wrote also, 19 matter also there.
My lords.
That 19.
Have you got it?
I mean,
Lordship, I have received the instruction. What has happened, in fact, my lords, is that there is allegation that there is a stay order in the NGT case pending. And despite that stay order, there is some dispute going on, and this present petitioner is not abiding by that stay order, your lordship. That is why the sub-collector has been directed by the EDM, who is the authority under the petroleum rules, my lords, to cause an inquiry, your lordship. Today, your lordship, the date was posted. I have advised them and they have referred it to another date, my lords.
Interim order is there to continue.
My lords.
After vacation.
I'm deeply obliged.
Interim order, your lordship, I directed that that meeting shall not be, there should be no sitting of the meeting.
No, I have already passed some sort of interim order.
The lordships was pleased to
Which
postpone.
as an interim, it is directed that the meeting in terms of notice should not be held for a period of 1 week. Let it continue there.
Lordship.
that a second matter I am appearing.
Second matter is PIL problem.
That's a PIL, my lords.
Second matter is not a PIL, my lord. Not a PIL, but it is a division bench matter. But in the first matter also, I have instruction to appear in the.
File your objection. File your objection.
Yes,
Bring
sir.
your vocal.
Copy of the writ petition, sir.
My lords.
Interim order to continue.
I'm deeply obliged.
Vacation for a date कर दिया. Second week of July. Second week of July. Yeah. The other matter I am releasing. Again, if it is necessary, it will be brought here.
Lordship.
Second matter to release. It's a parted matter somewhere.
Is it the pattern matter before the Honorable Chief Justice?
Okay, all right. I am releasing that.
Date has been fixed.
Second file release. Na? Yes.
Item 30.
In this case, I have sought for a direction to OP number 3 to construct the daycare subcenter at that.
Please, bring the level to your, a mic to your level. Yeah.
In this case, I have prayed for a direction to opposite party number 3 to construct the daycare subcenter.
You are affected.
I am affected because I am the chairman of the school over which the daycare hospital is going to be constructed. In fact, a daycare hospital is in existence, and for renovation of the same, money has been sanctioned. But
and now they are going to construct a new one.
Now they are going to construct the day center on the school premises. That's why.
Who are you? Who are you?
I am the chairman of the nodal.
Chairman
of the school, nodal school.
Of the existing healthcare center.
No, I am the chairman of the school.
Now,
which they are
now construction is taking place in a school compound.
My lord.
All right, you take a lawful decision.
Copy.
Copy भी देना है जी.
Agua
दो ना
I'm sorry.
If you have a grievance against state, why are you not serving copy and bringing the matter?
I'm sure.
Innocuous
I
prayer. Retribution involved innocuous prayer. Please. And as a decision is required to be taken by competent authority, the opposite party number three, the OP3 is directed to look into the grievance of the petitioner by annexure
5 pages.
Yes, this is Annexure what series?
Annexure 5. My representation to the
Representation is Annexure 5 series already. Running page 18 and 19. By disposing the same lawfully in the involvement of parties likely to be affected, at least within a period of 1 month from the date of communication of order.
till then,
Free copy of order be handed over to State Council.
till then, they must.
Item 31.
Item 31, my lord, this is a organ transplant case, kidney transplant,
Kidney transplantation.
my lord.
Kidney transplantation covered order ଅଛି ହେଲା?
Oblast.
देखिए करवा covered order ଅଛି. Yes. Free copy of order be handed over to State Council.
Item 32.
My lord, I'm challenging page 21, my lord. That is the Tahsildar rejected my mutation case due to lack of probat, my lord.
Due to
lack of probat.
Probate, your lordship.
Due to lack of
probate.
The will has not been
Probate.
probated, my lord.
My lord.
Which area?
My lord,
Sonpur.
Rampur, Subarnapur.
Subarnapur.
My
Kahin
lord.
judgment ଦିଅନ୍ତୁ.
Subarnapur ଟା ହଉଛି ମୁଁ ପାଇଲିନି,
That was a
Balangir-
past of
Subarnapur is a part of
Balangir, my lord.
Balangir.
My lord.
So Balangir judgment ଦିଅନ୍ତୁ.
My lord.
So Ponda, why these sort of cases are still coming? My judgment already reported could have been circulated to all registering authorities and the consultants. There is unnecessary litigation.
My lord.
Covered over, aligned. Yes.
Oblige, my lord.
Item 33.
May I please, your lordship? The petitioners are slum dwellers. Your lordship may kindly have a glance to the notice at page 33.
33 is.
Page 33.
Notice ପ୍ରାପ୍ତିର 24 ଘଣ୍ଟା ମଧ୍ୟରେ ଜବରଦଖଲ ଉଚ୍ଛେଦ କରିଦିଅନ୍ତୁ.
They are staying since last 35 years. Electric connections are there. Water connections are there. They are getting all social benefits.
You have not been evicted as of now.
I have not been evicted.
So I provide you opportunity.
If your lordship, similar case, your lordship passed this order.
You will be provided with opportunity, you will be
Yes,
protected.
yes.
You will be protected,
Yes.
that's all.
That is paragraph 5 of that judgment.
NAC, Mr. Mishra, you are not there.
Municipality. This court finds strength in the submission of Mr. Samal and counsel for the petitioner that there should be compliance of natural justice before giving effect to any such notice. This court finds that it is a fit case to be remanded to the executive officer Balangir Municipal to provide opportunity of hearing to each of the petitioners and passing order in accordance with law in the involvement of the petitioner.
Okay, all right, consequential order, similar order,
Yes.
but date annexure should change over.
Annexure 3, ma'am.
Other one also same matter?
Same, my lord, same.
33, 34. Prayer court for the para 5 onwards type. Yes.
Item 35.
After 30 years of publication of final ROR, the revision was entertained. My lord, I am covered by your lordship.
37.
No, my lord, 15B.
15B.
But 30 years after, my lord, your lordship judgment covers the field.
Covers the case, right? But I have to give them opportunity of hearing.
Yes, my
The
lord.
private opposite parties are also there, your lord.
Private parties are there,
Well,
then notice has to go, Mr.
Yes, sir. Yes.
Notice for taking, yes. The read application.
My lord, here in this case which I am relying upon, your lordship said that in 37, though there is no bar, but still then as per the
Reasonable time.
reasonable time, Article 137, your lordship extended.
Right.
But here 1 year is provided in the act, it is filed after 30 years.
This is this is a proceeding pending or it is disposed of?
So directing recording in the name, my lord.
Annexure 3.
Annexure 1 is the impugned order. I'm sorry, sir. My lord. Annexure 3 is the impugned order.
3.
Annexure 1, sir. Annexure 1 order.
Annexure
dated
3 is the petition.
Petition, man.
Okay. Annexure 1. Impugned order NSO 1 is under challenge on the sole premises of entertaining section 15B proceeding after 3 decades, almost 3 decades. Petitioner seeks coverage of the judgment of this court in WPC 4602 of 2016, delivered on 25/7/22. There are private parties also involved herein. This court is inclined to issuing notice accordingly. Liquidations being filed, notice be issued to private parties fixing short returnable date. Okay, matter be listed after the appearance of private parties, preferably on so and so July last week. In this case, notice as above. Till next listing, there shall be stay of operation of the order at NSO 1.
Item 36.
My lords, in item 36, my lords, may I please, my lords, I am appearing for respondent number 2, my lords. Yesterday night only I received the copy, my lords, and I'll be able to assist my lords anytime during next week, my lords, subject to your lordship's convenience.
Who is for petitioner here?
My lord, I am for the petitioner.
Okay, let it come after vacation.
My lord, here I have been blacklisted. I've been blacklisted.
Blacklisted, right? A judgment has to come.
My lord, here what has blacklisted? My predicament is, your lordship may kindly see annexure 1.
Mr. Ghosh, other side is asking for time. You know, writ appeals are going on refusal of time even.
My lord,
So
but
therefore, why do you
what
hurry?
I'm playing for an interim relief on the ground.
No, my lords, I have to assist.
I'm aware, my lord.
No, my lords, I have to assist your lordship.
1 minute.
Staying of the impugned order amounts to allowing of the writ application.
Yes, absolutely.
Yes, but here what has happened, by blacklisting me, they are putting in the website so that I cannot go in for any other tender.
You have to suffer for some time, Mr. Ghosh.
Your lordship may say only one thing. This may be subject to result of this writ petition only.
What may be? What may be?
Blacklisting. Because I
It
cannot.
is always,
No,
if you succeed, this blacklisting goes.
No, I cannot participate in any under tender.
No, that. So
That much you
some
got
sort
to
of interim order not possible.
Only next
Is
week,
counsel appearing?
Rashmi Malhotra, my lords,
Rashmi Malhotra.
for respondent number 2, my lords.
You are for the
Respondent number 2, my lords.
OP
OP number 2, my lords.
He is they are the main contestant.
6
My lord,
times
we have to take notice.
to bring objection. Okay,
My lord, I am appearing for Union of India, OP number 1, my lord.
okay. Anchor or Lakshivana. There is also appearance on behalf of Union of India. You considering final adjudication is necessary. Place this matter in 2nd week of July. Counter if any. Further response to the counter if any we filed in the meantime.
3 is there, man. Another party is there. If the
Item 37.
I'm so grateful, my lords.
my lord, your lordship may kindly call it an reopening week, because
2nd week ରେ ଆସିବ କାହିଁ ବ୍ୟସ୍ତ ହଉଛନ୍ତି? Yes.
ମୁଁ ଆଜ୍ଞା କୌଣସି ଟେଣ୍ଡର କରିପାରିବିନି, ସେମାନେ ଏମିତି କରିକି ଲେଖିଛନ୍ତି।
ଶୁଣନ୍ତୁ, once you are blacklisted, you have to suffer for some time. Unless until the order goes.
My lord, there was no MOU and I have been blacklisted, my lord. No MOU was signed.
Unless final hearing is possible, I will not list it.
My lord, 1st week of July ଥାଉ। ହେଲେ ଆଜ୍ଞା ଗୋଟେ ଜିନିଷ
Yes, 37.
My lord, 1 month. Your lordship may call it in the fresh admission category, because notice is not, they have appeared.
What is there? Fresh admission
sir,
after notice? I will be finishing list. Why are you bothering?
ଆଜ୍ଞା ଆପଣ ପାଖେ ଆସିଲେ ତ?
You have the liberty to make a mention on that day.
ଖାଲି ଗୋଟେ
I may prioritize the matter. Why are you worrying now?
date ଟା ଗୋଟେ
Yes, 37. Date will be there. Date will be there.
It's a fast content. And on the last occasion, lordship was pleased to direct the.
37 is a content matter. What is the hurry?
Last time your lordship. Last time your
Directed
lordship called
to-
for that record, WPC 1004.
No, 1224 of
8224 of 2023.
1004 is there.
No, my lord. That is WPC 8224.
Actually, it has already come.
No, my lord, it
ନାଇଁ
has
ସେଟା ଆସିନି ସେଟା
2022 ଟା ଆସିଛି।
ନୋଟିଂ ଆସିଛି ଯେ ସେଟା ଡିଭିଜନ ବେଞ୍ଚ ରେ ଯେହେତୁ ଅଛି,
8224.
ସେଟା ଭୁଲଟା ଆସିଛି
8222, 8224 ଅଛି ଏଟା।
8224 of 23 এটা 22 ହେଇଥିବ
ଏଟା 22.
ଆପଣ
ଆଗରୁ ସେ order ହେଇଥିଲା ପରା।
ହଁ last time your lordship direct to call for that record but noting is authorized my lord.
No, my
A pending case listed before the division bench.
no 25 order says it has to be listed with 8224. Oh yes, in 45 it became 23. So what is the correct file? 23 is the correct file.
23
Yes,
is the
ma'am.
correct file. Your lordship may kindly see noting
Noting
in the cause list my lord.
me. It is pending case before
Division bench. That's why it is not.
after vacation ଆସିଲେ ସରିଯାଇଥିବ ଦେଖିବା କଣ ଅଛି ହେଲା। ये 822422 is mistakenly brought and released. Actual file required here is WPC 8224 of 2023. Hello. Place this matter along with such record after vacation.
Maybe pardon lordships. In the second sub-contempt, the copy may be served, your lordships. There's a second sub-contempt against the Assistant Commissioner of Endowments.
Second
Copy of the
second contempt.
Yes, yes, my lord. In contempt number.
In connected contempt.
Connected contempt, that is 255 of 255 of 23. Yes, copy will serve.
In the meantime, copy ଆପଣ appear କରୁଛନ୍ତି?
Again.
Okay, be served on Miss Naidu. Hello. By Tuesday. That will
Pleasure.
That will be in
Right.
yes. Yes.
For orders item 38.
Though, my lord, this matter have been listed on my mention in the interim application number 5337 of 23. My lord, it can be disposed of if your lordship allows.
It's on. What is the miscase?
My lord, miscase is your lordship granted status quo on 27/3/2014.
Yes.
Your lordship may kindly take up my miscase. Here, there, after the status quo was granted, my lord, the opposite parties 4, 5, and 6 started constructing. I moved the police authorities. Your lordship will see annexure to page 6. The Tahsildar even writes to the IIC Sohela PS regarding adherence to status quo order over the suit property in accordance with the order of the Honorable High Court in WPC number
Then
section.
what more order can be passed?
My lord, here, my lord, the Tahsildar writes the police to do so. The additional district magistrate writes to the police to do so. Police is standing and allowing them to construct.
Then you bring a contempt. Why are you pursuing?
My lord, police is not a party here. I cannot bring a contempt directly against the police here, my lord. Your lordship may direct.
Why? Anybody obstructing the operation of the order cannot be brought as a party to the contempt proceeding? Injunction day, even they can be implemented.
Your lordship.
Bring contempt so that if you ask your Tahsildar,
I'll instruct you, Lordship.
Once status quo order is there,
Lordship.
that has to be obeyed. And there appears there is shifting of responsibility from one to the other. Now it a lie over kuru chuti pare dekhta. You in the meantime you may instruct the Tahsildar accordingly.
Lordship.
And if he is so advised, he may bring a contempt also.
Interim, that status quo may be extended at least.
Yes, interim order extended.
Lordship may fix a date according to.
Prepare after vacation, I may close this matter.
Yes, my lord.
Final hearing.
Today also I am ready, but senior is also ready. He is there.
Next 39.
Lordship will fix a date subsequent.
Yes, it was done last week. Is 39.
Item 39, matter is adjourned to after vacation, but inadvertently interim order was not.
Why it would be adjourned?
Yeah, already.
It would take 2 minutes.
There.
Yes, it is already adjourned.
It will take 2 minutes to dispose of. If it was adjourned.
Okay.
Already.
Okay, there is the inadvertent omission of extension of interim order passed on 22/23 in the order dated 8/5/23. This court
It was specific.
adjourning the matter to after vacation. Direct contact. No, that day you were not there.
Yes, I was there.
That's why the matter was only adjourned. So interim order cannot be extended.
I am here also.
Huh?
We both are here.
No, nobody was there. Only opposite
Yes,
party was there.
He is,
Since it is the election case, I said,
he is telling the election case to take it today. I am here and my lord, there is no time.
no, then this matter will come next week. It's an election matter.
Yes,
And-
yes, ma'am.
Oh,
And it was specifically targeted.
Let's the matter next week, interim order dated so and so to continue. Get ready.
Well, sir,
I remember two election cases were there, but the next case was Mr. Mishra. ଆପଣଙ୍କର ଆସିନି
ଆମର ବି କାଲି ଆସିଗଲା
nobody done those are last two cases
Covered by your lordship judgment.
covered, but why did you not appear on that day?
In fact, rushing.
So I thought maybe you have no interest.
matter adjourn ହେଇଗଲା ପରେ ମୋର
All right, next case.
But next week on 16th,
item 40 minutes.
on 16th or 17th, my lord.
Yes.
16th.
16. Yes, item 14.
40 minutes, I prayed very limited prayer.
Huh.
Last
This
line.
is a response case.
Sir, your lordship directed, keeping in mind 13.2, my application will be decided. Only one thing is left out, that is relaxation scheme. Relaxation, if your lordship remember, just to recapitulate your lordship memory, your lordship in the first instance directed them to decide my case relying on the relaxation scheme. They didn't decide this. On merit, they decided that I have not complied with the fire norms.
That
In the meantime,
matter.
Khali keeping in mind relaxation scheme. That much I want. In the meantime, that officer Miller changed. That officer who is there at the time of measurement, he is not there. He doesn't know ABC of the case. Case decided here. But I pray only very limited prayer.
But that relaxation is a part of the
yes,
scheme.
that is my
Therefore, I
specific case.
need
See,
indication
sir,
of that.
one officer asile, he says that unless relaxation scheme is court specifically says about applicability.
Now, why should court say?
Well, that he
place it may be open to the petitioner to place reliance on the relaxation scheme for consideration of authority. With this observation, the miscase stand disposed.
Sir, it is 14 ghar, actually construction prior to 17.
That's all. No. Yes, next.
All right.
Otherwise, they will take it to be granted. High Court has referred, therefore we have to be obliged by that.
18 दिन जाकर 4 मास ହେଇଗଲାଣି sir.
41.
For addition item 41.
In this case, my lord, the case was dismissed for default. I filed a petition for CMAPL. It was restored. Thereafter, again, it was dismissed, my lord, because of my illness.
Whole matter, 2001
Yeah,
case.
2001 matter. But in fact, so far CMAPL is concerned, so Vidyadhar Pradhan was appearing. So far writ application is concerned, that his name has not come. So I think my pray matter taken up on Monday, I will inform him.
Mr. Pradhan was appearing for
In the CMAPL matters.
in the CMAPL.
CMAPL. That was restored. Then again, it was dismissed because I could not read in time. So unless his name comes, minors, then the opposite party will
No,
go
now
on.
the repetition has come for hearing.
Yes, repetition has come, but his name probably doesn't appear.
You are the counsel for petitioner.
I am the counsel for petition. There is no problem.
Mr. Pradhan appears for OP.
OP. He was appearing for OP in so far that CMAPL is concerned.
CMAPL it appear kariparibani name. No, the name, the counsels who are all appearing for a private OP, their name is appearing.
I'm ready, my lord, so far.
Argu.
Only my kind of
So far as in main writ petition, my lord, our name R. Rath and SP Mishra is there, my lord.
Pardon?
Mr. R. Rath and SP Mishra is there.
Yes, Rajiv Ratha and
SP Mishra, my lord. So far as my lord, we
Their
don't
name
have.
is there in the list.
My lord, in the meantime, my lord, we don't have in the brief, my lord. So notice is to go out. We don't have the brief, my lord.
Thing is that, my lords, my case is that I have not been heard, expert judgment. We have not been made a party, and this may be remanded for hearing by the original authority.
Who is proceeding?
OLR proceeding. He says that there is a, my lords, tenancy and
Impugned order.
Impugned order is annexer. It is an annexer 5, my lords. Page 9. Page 38, my lords.
You are Subhash Chandra Mahapatra.
My lords.
I am Subhash Chandra Mahapatra. It was raised in the name of Prasanna Kumar Mahapatra, but by that time he sold that property in favor of the petitioners, and one of the petitioner appeared through power of attorney.
You are not a party there.
No, I was not party.
You are not a party.
We purchased the property before the proceeding was initiated. This order was passed on 16/9/2000.
By the time the order was passed, you are already a purchasee.
We purchased kind of a last paragraph -3. We purchased the property on 21/6/2000.
Then when the order was passed?
I was not there. We
you are
stepped,
not the owner.
No. I have stepped into SUO as on that date, but I was not made a party. One of us.
No, now the difficulty is they have already written the brief. What to
Mr.
do?
Vidyadhar Pradhan, so far CMAPL is concerned, Mr. Vidyadhar Pradhan was appearing on behalf of the contesting opposite party. I will inform him, my lords, may be taken up on Monday.
If he comes, it is all right. All right. List this matter on Tuesday.
But our name is concerned, you losses may say that we don't have any.
It is better let you take notice.
Notice,
on the
my lord,
parties,
because
I'll take notice.
he may again say, I don't have the brief.
All right, I will take notice interim order to continue.
Okay, they mentioning on behalf of OP1 by Sri SP Mishra, learned counsel, that on the dismissal of the writ application for default, their client has taken back the file and they don't have the brief for the timing at present. Okay, in this situation, this court find unless there is notice to the private opposite party one.
He died and we have taken substitution. He died, we have taken substitution.
And the substituted LRs of OP1. Substitution already they taken place.
Yes, ma'am.
To the LRs of the original petitioner one. Where is the amended cost title?
Amended cost title, I'm submitting.
Huh?
I am giving that.
There is no amended cost title.
I'm submitting that.
You are sure there has been substitution?
Yes, my substitute allowed it. Cost title. I'll check it there, minutes. Because
just 1 minute, 1 minute.
That CMAPL, sorry, in CMAPL.
In the REIT, there is no substitution.
In CMAPL, I made substitution.
That will not work here.
You work here. I'll file substitution by tomorrow.
The Mahapatal and counsel appearing for the petitioner makes a statement that pendency of the REIT application, Nilakantha Mahanti, the petitioner one, has died. Matter requires substitution of opposite party number 1. Let the substitution application be filed within 2 weeks. Matter to come immediately after vacation. So unless party comes, you can't file the substitution petition.
Party is coming.
Party is coming.
Earlier,
so will you be in a position to file this case by Tuesday?
By Tuesday.
Okay, by Tuesday. Place this matter on Wednesday.
Yes.
So that we can at least issue notice in the substitution.
During vacation, it will be solved.
And that may bring them here.
Yes, interim order earlier.
Interim order to continue. 2001 matter unnecessarily pending here. This is again a 2010 matter. Yes, next case.
Item 42.
Due to cardiological problem, Mr. G. Behera has authorized me to place the matter before Lordship.
You will place.
Yes. If the Lordship will allow, otherwise my Lord friend is asking for.
Argo. 2000 matter.
Yes.
10 matters.
This matter, the Lordship has already had the matter on earlier and passed the judgment on 1st November 2016.
Then how this matter comes again?
And the writ appeal in the because on the point of res judicata since
demanded.
Yes,
it is completely misled the facts.
No, that is the
completely misled.
Though parties were
misled in the petition.
The counsel, he has misled there, cannot be a substance here.
Yes.
He has misled there, cannot be a substance here. Why should we issue to involve to such issue? Yes, argue on merit again.
My only question.
Where is the division bench order?
Your Lordship should kindly see. In the, your Lordship has everything as mentioned in your Lordship's judgment at first.
Despite that, the division bench interfered.
No, but why it has interfered? Because those parties were same, but your Lordship has allowed the writ petition only on the ground since it is earlier decided by the court below. Second time it is not maintained. That's ground. Your Lordship has allowed.
Where is the division bench order?
Order division bench. I have more time. My lord, that I think I have no copy.
Division bench order kind. This is writ petition only. That must be a writ appeal.
Writ appeal order is.
Writ appeal order. Either of you produce. How can I get that? Mr. Mahanti, you had gone probably in writ appeal.
Yes, they have gone.
Let us see what is the extent of interference.
Only one question is
either of you produce the copy.
Nice.
Argue kale, order obtain kale, you don't have the order copy with you.
Pass over.
Let's the matter after vacation. As none of the parties is in possession of the division bench order copy of division bench. Writ appeal number kौन?
Writ appeal number, my lord.
Let's the matter after
528
vacation.
of 2016.
After vacation, the second week of July, along with AA records in AA.
528 of 2016.
528 of 2016. 2016.
Yes, ma'am.
Disposed of on.
Disposed of on
counsel, so Vichitra counsel. Your clients must be laughing there. These are all live streaming. All right, let there be that reputation to you. Yes, next case, call next case.
Item 43.
Dates cut in there,
What, my lord?
Yes, 43.
Item 43. Kindly.
Item 43, my lord, that is giving me, my lords, the LPG retailership, my lords. Area is Dhenkanal. Sorry, my lord, Delang. There is my humble contention that there is no such Mauja like Delang or place like Delang. That is what my lords in the
14 matter after vacation also.
Covered by your lordship. No, it cannot be. I have gone through the decision.
It's well covered.
With due humility, it will not be covered. With due humility, it will not be covered.
So after vacation also.
Miles, only thing is that Miles, I may point out that Miles kind of a class 2 order dated 25.
More Bortan judgment likhiyaku mood.
No, judgment nahi. 25/2/2016 re Hon'Ble Court has given direction to the government, Tahsildar, to give a report. That report maybe copy of the
share the copy to the petitioner and also the Mr. Mahapatra. In the meantime,
from the one second. There is Dilip Ball, the judgment which I passed on. This is your lordship's judgment on 21st of April 2023. This is short dispute. The advertised location is Delang.
Mr. Acharya, I have so many judgments pending at my hand. Division bench, single bench. So unless this Saturday there is some inauguration.
I think my brother
Saturday, Sunday there is some inauguration. What to do? We don't get last Saturday. Every Saturday, some judge of the Honorable Appeals Court. Every Saturday, some judge of the Honorable Appeals Court here.
Some inauguration also.
Can't even ignore pending judgment so that I can take up new assignments.
Interim order.
Interim order achi.
Yeah, that is what is stopping us.
Interim order to continue.
Gas distribution, LPG distribution in a rural area. So that is why we mentioned it. That has come and mentioned. That's
all right.
He has given the land for renture.
Second week after vacation. In the meantime, copy of reports be exchanged to the councils.
May fix a date so that it can come on that.
The second week after reopening. Yes.
Item 44.
ये भी ऑटो मैटर कौन पे ऐसे What is?
The matter relates to operating of medicine store, 24-hour medicine store inside the campus of the CHC Chandbali.
So status quo order is there?
Status quo order is there.
After vacation.
Lordship may only one prayer, your lordship may absolute the status quo order because if anything will be happen, if the court will not function, that something is wrong, they will demolish.
That order is continuing since 2018.
Lordship, it's continued.
So what do you mean by permanency? Interim order to continue. August, second week August. Yes.
Item 45.
May it please your lordship. I filed an annexure, so additional affidavit. That is the
What is the urgency? What is the urgency?
ନାଇଁ ସେ ଘରଟା ଭାଙ୍ଗି ଗଲାଣି ସାମ୍ନାରୁ ନାଳ ପାଣି ପଶିକି
କଣ
ସେଟା ବର୍ଷା ଦିନ ଆସିଗଲା ଆଉ ପୁରା ଆଗ ଗୁଡା
who is appearing for opposite party?
My lord.
Senior advocate Mr. Pradipta Mahanti.
My lord. I am
there.
on behalf of Mr. Mahanti, my lord. My lord, it's a fresh matter, my lord. No, my lord. We'll take
Counter file ହେଇନି.
Counter file ହେଇନି ମୁଁ I will not join issues ଏବେ ମୁଁ ଝଗଡା କରିପାରିବିନି municipality ସାଙ୍ଗରେ ଖାଲି ଏତିକି ଯେ ସେତିକି କୋଉଟା କେହି ଦେଖିକି ଆସିଲେ at least ସେ construction पे କିଛି step ନିଅନ୍ତୁ if lordships direct.
Ask Mr. Mahanti be present on Tuesday. That's good. There is a request for adjournment on behalf of Sri P.K. Mahanti, Senior Counsel. Matter stand adjourned to Tuesday. Yes, ask him to be present that day.
Yes, ma'am.
I will also apologize regarding matter.
My lord, I am on VC 46, my lord.
Yes.
I am for the petitioner. In an election matter of Sarpanch, I am the elected Sarpanch, my lord. I was opposite party number 2 in the election petition. I filed an application for amendment. Vide annexure 3.
Amendment of the written statement.
Yes, my lord, yes. Page 21, my lord, annexure 3. Only change of 2 names.
Just 1 minute, 1 minute. Page
21.
Yes, come to the proposed amendment.
My lord, your lordship may kindly paragraph 1, third line last, my lord. I want to delete.
Read the whole para.
My lord, in the written objection, the OP number 2 in page para 8, 3 para 8, in the first line after the word village and before the word under the word Khogdapal may be deleted and in its place Kalikapur may be written. Then similarly, in the second line of the same page, 2 after the word under and before the word and the word Madhupura GP may be deleted and in its place Baigonbadia GP may be inserted. This is the amendment, my lord. That has been rejected. On the ground, I mean, next page 22, my lord, same, my lord, Khogdapal khali change abo. It has been rejected on the ground that evidence has already been taken. And your lordship by the interim order directed that let hearing evidence may continue, judgment may not be delivered. Now, regarding my residence at Kalikapur.
Mr. Bag, make it clear, if it is a surprise, these names were not earlier found place in the election petition.
My lord, election
names
petition
of the GP were it not available in the election petition?
Yes, election petition page 11, my lord. Annexure 1.
Yes, bring to the notice of the court where it is appearing there.
It is your lordship kindly cause title, my lord, opposite part number 2. It was written Khogdapal, my lord.
Yes.
That's why in the objection it is written Khogdapal instead of Kalikapur.
So therefore there was no material change.
No, my lord. Only it will not change the election, my lord. In the grounds of election condition for eligibility, it is not a ground, my lord. Only to make the clarification.
Now you wanted to bring Kalikapur
in place of Khogdapal.
And then
Baiganbadia in place of Madhupura.
Baiganbadia.
Baiganbadia in place of Madhupura.
Just from the election petition show that these names do appear there.
My lord, election petition, my lord, your lordship may kindly see paragraph page 11 annexure 1.
First title, definitely his village is there.
Village Khogdapal. Then your lordship may kindly turn to page
body of the petition.
Body of the page, paragraph 3, my lord, middle, Khogdapal.
Yes, Mr. Nandi, there is no material change.
Yeah, entire election petition is based on that. My lord, I am filing the counter.
I have not been served with a copy of the counter.
Yes, yes, I have already
scope of counter here, Mr. Nandi. So I'll not accept any counter. This is statutory proceeding. You must have your objection there. So place from your objection there.
Yes, we have raised objections there. Raised objection there, my lord.
Yes. So from objection, argue. You can't file a counter here. Sabu case को read petition रे कहीं convert कर दो.
नहीं सही थी हमें देख सब कथा
then place from that.
My lord, to prove my residence, my lord, I have filed annexure 6, 7, and 8.
One minute. Let Mr. Nandi satisfy through his objection. Mr. Nandi, you have to appreciate, yes, all right, if these names are altogether not there at all, then somebody is bringing, then you may say, sir, written statement is something, now amendment is something. So
therefore, I am trying to, your lordships, say that kindly go through the annexure.
Materially affect.
Materially affect, enter, hi amara crux point. से सेठी जत्ते बळे इलेक्शन लढी थिले से इलेक्शन बळे सबु बळे से प्रेस करचंती मो घर होची खगडापाळ एफिडेविट फाइल करचंती इन बिफोर द तहसीलदार वीडियो दैट इज annexure A/4 13 page 13 to my counter. Annexure 2 to my counter at page 10.
Page 10 counter को गलनी अपन.
हाँ से टांकी सही से देइछन वो सेटा देखो.
Your objection was not filed here.
Yes.
Your objection to the amendment application was not filed here.
Yes, my lord. Annexure 4, my lord. Page 23.
Annexure 4. Come to annexure 4 and
yes,
go from there. What is your objection there? Yes, this is your objection to amendment application.
I'm reading now.
So you said you want to withdraw the admissions. Para 6 again, withdrawing admissions.
Yes. The proposed amendment is changing the nature and.
Para 7, it can't be construed to be a typographical error.
Yes.
Para 8, he has shown affidavit showing to be addressed to be Khogdapada.
Yes, ma'am.
Hmm.
Yes, ma'am.
So that's your objection there, and that has been considered.
Well, before going to that, your lordship, earlier he has filed a writ petition here. That is WPC 3408. That has been annexed as annexure.
In the same election dispute?
Yes, madam.
Yes, that is annexure A/11 you have filed.
That is annexure. Yes, A/11. Your lordship gone through that.
That was on what issue?
He has suppressed that order.
That was on what issue?
That was, my lord, my evidence was closed.
Evidence is closed.
Your lordship imposed a cost of 10,000 and allowed me to give evidence.
And thereafter you are bringing this application?
No, my lord. Prior to this, what happened, my lord, mistakenly a CMP was filed. That CMP has been withdrawn. Thereafter, the writ petition is filed. Because CMP was not maintainable, the writ petition is filed.
CMP not maintainable, your lordship go through the CMP, what he has filed.
On 7/2/23.
My lord.
And when you brought this amendment application?
Prior to that, my lord, much prior to that.
I have annexed that annexure A/10 as page 32. In
When
that
the
CMP,
court allowed the application and directed evidence.
Yes.
By the return candidate. But why then why you have not mentioned then that your application was pending?
My lord, CMP was pending. And CMP has been withdrawn on 14/2/2023.
All right, yes, Mr. Nandi, you conclude your submission. What is your further, any other objection?
in CMP, your lordship, he has filed a petition there. He has stated that his, what is the place of that affidavit at page 30, at page 41 of my counter.
Counter copy ta to mate dei nahanti.
Page 41 of counter.
CMP ta thibo.
I don't go to the counter, Mr. Nandi. Sorry, there is no room for counter here.
Counter ne CMP ra jota file करते मैं CMP ta देखिया पे चाहूँगी जेहेतु I have filed in counter therefore I
You could have brought those things by way of memo. Why have you filed a counter? Statutory proceeding re counter ro koti place thae. Only if some documents are not brought on record, you may file it by way of a memo. Page 41.
Page 41.
Some copy dei nandi.
Na copy dei nandi.
Okay, your file, you must be having that copy. It is your CMP.
But I was not the advocate, my lord. So I have not the copy.
Yes, what do you want to?
Affidavit say that the Biswanath Patra, aged about 47 years, left Krishna Chandra Patra at Khograpar, Baliapar, Baleshwar. Everywhere they have stated Khograpar and Baleshwar. Now they and therefore the affidavit they have filed there before the video Tahsildar Jaleshwar, Biswanath Patra at Khograpar.
Now what is the interim order?
Interim order
evidence may continue, but judgment will not.
No final outcome.
Yes,
but,
yes.
All right.
Yearly order, my lord.
Hearing concluded.
My lord, only my lord, your lordship, I will place before
Judgment reserved.
Annexure 6, 7, and 8.
Yes, yes.
Annexure.
Your lordship passed orders at page 47. Your lordship, I am reading of that.
But the impugned order has not been passed on those. Impugned order is only on the.
Whatever it may be.
The
direction was the.
Yes, Mr. Nandi, continue.
Yes.
What do you want?
This court quashing the order at Annexure 3, providing opportunity to the opposite party number 2 to bring his evidence at least within a period of 1 week from the date of communication of this order, meaning thereby there shall be commencement of the evidence of the returned candidate petitioner.
So therefore, you submit with this order, there is no scope for bringing such application.
No, no, I don't know. Direction here in 13th February 2000.
Mike agare.
13th February 2023 positively. Further proceedings shall also be concluded within a period of 6 weeks from the date of commencement of the evidence of opposite party number 2. This court also directs that the trial court there should not be adjournment of the proceeding at the instance of the petitioner herein after the proceeding commencement on 13/2/2023. That is a earlier direction. Thereafter, again they have filed this and they have not placed before your lordship and obtained the stay order.
So therefore, you say once the High Court has targeted, it should have commenced from the evidence stage only. No other application would have been taken into consideration. Yes. I understand that.
And but my application was rejected by order dated 1/12/2022, my lord. Not that after your lordship's order. Annexure 5.
Yes. All right. I have understood that issue. I'll deal with that. Don't worry.
Only, my lord, I pray your lordship may kindly see annexure 6 and 7, 8, my lord. My place of residence. I have filed the school certificate, high school certificate.
If the
You will not, both of you will not conclude your, I have already reserved for judgment. Yes, all right, anything you want to give it in written note of submission.
Yes.
Yes, Mr. Mahapatra, last case, what is this?
Item 47.
By Friday, by
By
Monday.
Monday, June. By Monday, both sides, June.
This is a case, my lords, my learned senior's own property. He purchased it through third-party transfer from Dr. Mahapatra for clinical purpose. They allotted earlier for clinical purpose. Now, my learned senior wanted that the lease deed should be executed in his favor. Two contingencies. I understood that two contingencies. One is that he has already purchased it, a post-possession transfer. Post-possession transfer in the sense, Dr. Mahapatra, the opposite party number 3, who was earlier allotted the plot, he has not taken possession. He has taken possession and history. Before he has not taken possession, he has transferred it. In favor of the petition.
That is wrong.
Just a minute. 1 minute.
Contrary to his affidavit and wrong. Let him read his affidavit.
Let me complete, Mr. Mahapatra.
Now let's correct statements in.
Just 1 minute.
Yes, wait. So thing is that.
So your submission, it's a transfer without taking possession.
Transfer, he has taken permission from the authority. There is no dispute on that.
Okay.
He has taken permission from the authority.
Yes.
Question is that initially it was allotted in favor of part number 3. Then managed what happened, the lease deed was not executed in favor of part number 3. By the time this was transferred in favor of the petitioner, my senior, there was no deed existing in the name of the original allotee. So before execution of the lease deed, the transfer was permitted. VDA permitted. It's not that they have so much of taken it. VDA permitted. VDA granted permission. Yes, whatever construction of all these things. The allotment was for clinical purpose. Any amendment, that is what my learned senior is to return that insofar lease deed is concerned. Only two problems, whatever I have come in contact with position. Thing is that here in this case, minors have already decided a case. That is, I've given a copy of my Dr. Sashwati Mahapatra.
This copy was given last time.
Copy Deichanti.
This copy was given to your lordship.
In fact, Dr. Sashwati Mahapatra case, they are minors directed and decided.
Yes, Dr. Sashwat Mahapatra.
They are minors decided that yes, the possession, pre-possession or post-possession, how can it be settled? Thing is that they have the original allotee must have given money, consideration money, so as to purchase that property. That would be the best value. Then my learned senior must have applied for the lease. Then the day he has applied for the lease, the benchmark valuation will be treated as a valuation, and accordingly it will be determined and settled. That one part is over. I think it will. This will suffice the purpose. The second part is that what the BDA is insisting that agent date, when agent the date of the execution of the deed, they should give an affidavit that they have not acquired any possession of the property, any other property. That will be the only property.
That you give the so that
Any day they have not said that to me. I'll do it right now. I make the statement in court.
I am keeping it to next week.
Yes.
In the meantime, you give that affidavit.
Let him retract. Tell me the requirement. The first time this has been mentioned. Let him say what is the form.
But probably my learned senior
Volunteer.
Manas, I am making a declaration in court. I have no property in Odisha.
Mr. Mahanti, you just volunteer, file an affidavit tomorrow. File an affidavit tomorrow.
Very well.
I am keeping it to next.
Yes, that is what I will pursue there.
So once that reaches,
I coordinate with Mr. Mahapatra, and if he has any specific
all right.
comments.
That is
I am posting it to next Wednesday. You file it by tomorrow.
Yes.
So that let us.
Then they will examine it and they will say whether what is the defect or not. I will point out so that it can be settled.
Mr. Mahapatra looking to the.
Yes, madam. That is what I am offering.
Please try to resolve.
Yes, that is what I am in touch with, madam. I am in touch with her.
Format from him and comply.
Wednesday, hard in part Wednesday. I don't indicate anything.
Yes, madam.
I will be simply posting it to Wednesday. In the meantime, find out.
Yes.
Tripathi को नाम लिखा हुआ and महापत्र है ना. Mr. Mahanti को नाम लिखी हुआ.
I'm appearing in my individual capacity.
Pardon?
I'm appearing in my individual capacity, not a council.